Okay, we're ready. I'd like to welcome everybody to the meeting of the April meeting of the Water Quality Control Commission. We have an agenda. There's one item on it. Before we get started, I'd like to remind everybody to silence your cell phones. So the first item on the agenda is a roll call of the commission. And Ms. Jones, would you call a roll, please?
I will. Good morning. Commissioner Brankard. Are you here?
Present.
Present, okay. Commissioner Candelaria. Commissioner Fry.
Present.
Commissioner Harms.
Present.
Commissioner Laney. Present. Thank you. Commissioner McWilliams.
Present.
Commissioner Moander. Commissioner Patton. Chair Thompson.
Present.
Commissioner Velasquez is actually Commissioner Bayless.
Present.
Commissioner Vigil
Present.
and Vice Chair Zemlik.
Present.
You have a quorum.
Thank you. We have one brand new commissioner and one who was attended virtually last month. So I'd like to give Commissioner Harms, who is representing the Environment Department, just a minute or two to just briefly introduce yourself and your experience.
Thank you. My name is Niori Harms, and I have public and private sector experience in this field. And I serve right now as the Uranium Mine Reclamation Coordinator for New Mexico Environment Department. And I've been in that position for about 2 years.
Thank you. And Commissioner Laney.
Yes, Katie Laney. I'm with New Mexico Department of Ag. I have been in state government for the last 14 years. Currently with the Department of Ag, I am the Assistant Division Director of within the Agriculture Production Services Division. I oversee several regulatory programs. All of my experience has been within regulatory programs of various different types. Prior to the department, I did work as a contract for geoarchaeology in the White Sands Missile Range area.
Thank you. Thank you. Welcome, and we look forward to working with both of you. The next item on the agenda is approval of the meeting agenda. I'd entertain a motion to approve it. It was moved by, I didn't hear who moved it first.
I'll move the agenda. Thank you, Commissioner Brankard.
I'll second.
Okay, it's been moved and seconded. Since everyone is present in person, we'll just do these on voice votes, okay? So all in favor of approving the agenda, say aye.
Aye.
Opposed? Okay. The next agenda item number 3 is approval of the minutes of the January 14th meeting. They were sent out, I believe, yesterday.
I can motion to approve.
Please. Motion to approve second.
I'll second.
Any discussion? All in favor, say aye.
Aye.
Okay, agenda item number 14 is public comment, and this is an opportunity for the public to comment on items of interest to the commission, but not specific to the agenda item number 5, which is the wastewater reuse rule. So is there anyone wishing to make a public comment? Okay, hearing none, let's go on. So agenda item number 5 is deliberation in WQCC 23-84R, which is a proposed rule dealing with reuse of wastewaters. And this is both municipal wastewater, domestic wastewater, industrial wastewater, and produced water from the oil and gas industry. So we have had a rather lengthy series of of meetings on this, I believe 11 days of hearings. There's something approaching 20,000 pages of exhibits, although there is a lot of duplication. And at this point, I'm going to turn it over to the hearing officer who has submitted her final report. And so this is, the hearing officer, of course, is Mrs. Felicia Orth.
Thank you very much, Mr. Chair. I won't be talking a lot today, at least I hope not, as you lead the commission through their deliberations. I'm here in the event a commissioner has a question about what I wrote or typed up, or if the commission would like me to dive into the banker boxes I have behind me to find something in particular you think you remember, but maybe I could find it faster then you might be able to while you're in the middle of deliberations. It won't be quick, but I will do my best to share whatever you might need from the record. So unless there are questions, I'm going to turn it back to you.
Thank you. So this is a new experience for me. I've never participated in a rulemaking this extensive. I am very appreciative of the hearing officer's report, and I assume everyone is aware that it is posted on the NMED website under docketed matters for the Water Quality Control Commission. The hearing officer's report identified 3 questions, and I think that's a good way to structure our discussion. The first question was, should the commission adopt a rule at this time? Yes, ma'am.
Motion to reopen.
Thank you. Thank you very much. Yes, we need a motion before we go much further. We need a motion to reopen the discussion.
You are facing a motion to reopen the discussion to a motion filed by Mr. Maxwell.
Oh, that one. Thank you.
Yes.
Yes. So there was a motion filed by Nicholas Maxwell to request testimony from a professor at New Mexico State, Peju, Dr. Peju. That the motion was filed fairly late. So again, before we discuss the hearing officer's report, we need to act on this motion to reopen the testimony and allow or invite testimony from Dr. Zhu. So I would entertain a motion to reopen if anyone is so inclined. Commissioner Brankard.
Mr. Chair, I move that the commission deny Mr. Maxwell's motion to reopen the record.
I would second that motion.
Okay. It's been moved and seconded to deny the motion, excuse me, to deny the motion to reopen testimony. Is there any discussion? Are we ready to vote? Okay, all in favor of the motion to deny reopening the testimony, say aye.
Aye.
Any opposed? Okay, that the motion passes. And thank you for reminding me. So now we do go back to the discussion of the issues. Again, the hearing officer has suggested that there are 3 questions that need to be answered by the commission. The first question, as I said a moment ago, was, should the commission adopt a rule at this time? The second question is, should the rule prohibit discharge of wastewater to surface water and groundwater? And then the third rule, or the third question that the hearing officer's report poses is, must a discharge be required, or is a notice of intent, NOI, is that sufficient? So with that, I think it would be appropriate to take these in sequence. Is that okay?
Excuse me, Chair Johnson.
Yes.
New Energy County. I would just like to point out one error in the hearing examiner's, a hearing officer's report, and that is on page 8, paragraph 5. It says, New Energy Economy, parentheses, me, was represented by Council Mary Ellen Nasty and Christopher Dodd. Me presented witnesses Norman Baum and Justin Noble. The fact is that there was an omission there. The commission heard testimony from Dr. Abner Langosh for at least 5 to 8 hours. And so I believe that that is an error, and I suggest that the hearing officer's report be amended and that and I also would respectfully request you all to please bring your microphones much closer to your mouth so you can hear me better. Thank you very much.
Okay.
Chair Thompson, one more correction. When you introduced the second question, you said to prohibit discharge, and it's to prohibit discharge permits.
Okay. So
When you repeat the question, you can do it
I will do
correctly.
that. I will
Yeah.
do that. Ms. Nanassi's concerns about correcting the report.
Yes, I will file a substitute page. I absolutely remember Dr. Van Gogh's testimony, and I'm sure that the summaries of NEE's points under each of the major questions, and as we walk through the rest of the rule, that his testimony has been captured there regardless. But I will file a substitute page.
Okay, thank you. Okay, so it let me just call up the. So how would we like to proceed? Would we like to go in sequence to the questions posed by the hearing officer? Or is there an alternative structure that anyone would like to suggest?
I think going in sequence makes sense. Thank you.
Thank you. Okay. So again, the first question is, trying to find it here. Should the commission adopt a rule at this time? It's going to be a long day.
Are you opening it up for comment?
Yes, I'm opening it up for discussion. Yes. All right. Commissioner Brancard.
Someone needs to talk. So this argument comes largely out of the positions of the New Mexico Oil and Gas Association, Select Water Services. But their concern seems to be that this rule does not go far enough in allowing uses of produced water, and therefore, why not just send this back to the Environment Department to get back to work and do a better job. The assumption in that proposal seems to be that this commission can order the Environment Department to do something. I don't think we can. But more importantly, I think that the statute that was passed in 2019, House Bill 546, specifically provided an amendment to the Water Quality Act that required this commission to adopt rules regarding uses, et cetera, of produced water. And we're finally here, and I think we ought to do something. So I think we ought to make an attempt to adopt some sort of regulation at this point regarding produced water. I don't think anybody doubts that there may be a need for further rulemaking following this, but I think we ought to give it a start and get something in the rules regarding produced water, because that's what the legislature has required us to do.
I would agree with Commissioner Brankard that we do want to take this first step towards rulemaking. I think we should trust the department when they say that this would be the best path forward for them. We need to follow what was outlined in the Produced Water Act and square that with what's outlined in the Water Quality Act to use science-based data to create rules. So I think this is a good first step and we should proceed with rulemaking.
Other thoughts?
Uh,
Commissioner Zetler?
Yes. My additional thoughts are that with regards to the, the question of sending it back to NMED, I think during the course of the hearing, the biggest sort of unknowns that we were wrestling with were data from those that proposed we should wait a little longer to make rules. And so I think, NMED can't be the agency providing all the data from oil and gas in terms of water quality or in terms of standards. And I think that gap in data will, a year from now or 2 years from now, perhaps, leave us in the same place. And so, giving it back to NMED without some sort of indication from Select Water Services or NMOGA that there's going to be some advancement in the data that's provided upon which those standards could be based doesn't make a lot of sense to me. So that is in favor of adopting something now, to be clear, that doesn't, at this point.
Other comments?
I'll go next. I think that the rule as proposed is an attempt for NMAD to be able to collect more data. And it's some kind of a framework to do that with some protections. And with a lot of the changes that have been proposed, I think, it's the best way forward at this point. So I would propose that we accept some kind of a rule today.
Mr. Laney?
Yes, so after reviewing all of the docketed material, it's very clear that NMED is trying to establish a regulatory pathway by this rulemaking, and that they can't establish that without taking these first steps. The other thing that's clear is that in order to really understand produced water for NMED, they're going to need to understand the water quality, and they need this in place to do so. So I agree that at least some form of rule or recommendation needs to come from the commission.
Thank you. Anyone else? Commissioner Vehil?
I would agree with this because, have served on this commission for going on my 20th year. And I've gone through the dairy rules, the copper rules, and like you said, you got to start somewhere. And this is a very good attempt by the Environment Department. And like you said, nothing is perfect. And like you said, it's got to start somewhere. And this is the first attempt. There's nothing to say there. They can't come back. And, if we adopt certain rules, there's nothing to say that the parties cannot come back and revisit certain aspects of it. So at this point, I think we do need to start somewhere, and this is a good first attempt.
Okay, anyone else? I'll weigh in. I agree with what's been said. I also think that, and it's been brought up by a couple of the commissioners, that in order to go the next step to generate more information about potential treatment and possible reuse of this material, we need more studies. And I think that these studies are going to be at a bigger scale and will need a little bit more regulatory oversight than we've got at present. So I support the idea of adopting a rule at present. Commissioner McWilliams.
Well, it seems the overwhelming sentiment is that the way to move forward is to adopt a rule. I'm not sure this rule, and maybe we can talk about it going forward, is going to be what the environmental department and the commission want in terms of gathering that data. I'm just not sure that's the best way forward for that. We could be in a very similar spot in 12 months or 24 months from now and still not have the data collected.
Yes. Okay, so anyone else? All right, well, it sounds to me then that we are general agreement that we will continue to move forward and see if we can adopt a rule. But we'll continue discussion. So the second question that the hearing officer posed is that if the commission does adopt a rule, should that rule include a prohibition on discharge permits for discharge of treated produce water to ground or surface water? So we're talking about adopting a rule. Will it include a prohibition on discharge of treated produce water? Commissioner.
Thank you. Because in the proposed rule, we have a section where NMED can deny under the notice of intent, a project that they deem as unprotective or not protective of the environment. I do not think a ban on a discharge permit is necessary at this time.
I agree with that as well.
Thank you. Commissioner Fry.
On one hand, I don't see the harm in having discharge permits to regulate that. But on the other hand, the idea of the notice of intent does allow researchers from universities to do research without permits, which are costly. I'm on a project right now where we're having to get permits, and thankfully we had the money to do that. But I think it would make it difficult for university researchers who are independent in, or I would expect would be independent in their work on this. I think it would make it harder for them to do this kind of research. And if we are looking, if the idea of the current rule is to allow more data gathering and collection and reporting, then we'd want to do as much as we can to encourage university researchers and other researchers who would not have a lot of funding.
Thank you. Others? Commissioner Brankard?
Okay, so the opinions on this issue sort of fall into three categories in the evidence. One is that the data that's out there today requires a permanent prohibition against any uses of treated produced water because it's just really bad and can't be cleaned up. And that's the argument put forth by a number of the non-governmental organizations, NGOs. On the other hand, there is the New Mexico Oil and Gas Association, Select Water Services that have argued, presented data that, yes, you can clean it up. And so let's go forward. And why would you have a prohibition on discharge permits? Each discharge permit should be evaluated on its own. The petitioner in this case, the New Mexico Environment Department, has been pretty consistent in their testimony that there simply is not enough information out there at this point to adequately characterize and understand produced water, to develop standards about produced water. In other words, to develop good regulations about how to regulate that. And if they didn't have a prohibition on discharge permits, they would be forced case by case to evaluate each situation with lacking really the data and possibly have inconsistent results. But they are assuming that this gap in understanding standards data can be overcome. And so therefore, they don't see this as a permanent issue to prevent discharge permits. Okay. The problem I see is that what we have in the current proposal from the Environment Department is a permanent prohibition against discharge permits for untreated produced water, for treated produced water, and for surface water permits. And so that, to me, does not really coincide with the petitioner's position and the evidence that they have presented. And frankly, I am persuaded by the evidence that the Environment Department has presented that treated produced water can, in some form, be regulated, but we're just not there. And maybe the end result after a few years will be that they will decide that maybe they can't do it, but we're just not there to make a decision permanently on treated produced water. So I would advocate, Mr. Chair, that we accept this prohibition, but put a time limit on it. Okay? So that we're effectively in the section of this part of the regulations, was it 20.6.8? I think it's subsection 4, section 4, sorry, is duration, and it says permanent. We don't have to do that. We can come up with a date that essentially sunsets this rule. And so therefore we have not approved a permanent prohibition on discharge permits. It also gives department, the regulated community, the public, a sense that, okay, we have a time frame. And within this time frame, the Environment Department is going to have to come back with a new set of rules. What that will look like, I can't anticipate. You know, perhaps it's some granting of permits, perhaps it's no granting of permits, perhaps it's just an extension of the deadline for more time. I don't know. And hopefully we'll pick a time that's far enough away so that I won't be on the commission anymore. So that's my proposal. I just think that avoids the problem of saying that we have created a permanent prohibition on discharge permits. I don't know that the evidence supports that, and I think this deals with the reality of what we have now, that we don't have standards that we can enact for treated produced water discharge permits at this point, and we need standards. Thank you.
Other thoughts? I'll weigh in. I think that's a very good idea. Put a sunset time on this regulation with the expectation that in a year, 2 or 3, we'll have a lot more information. And that will allow the Environment Department to develop a regulation that specifically addresses the health and environmental concerns. I went through a lot of the exhibits, and I'm not quite as pessimistic as some people. I counted 15 exhibits that were submitted that specifically identified treatment methods. Most of them are in laboratory settings, bench scale settings, but and there's a tendency only to publish good results, but virtually all of them demonstrated an ability to treat water to very high level of quality. So I am very optimistic that in a few years, 2 or 3 years, there will be a body of knowledge that will support standards that are more appropriate, more defensible from again, the perspective of protecting health and the environment. So I really like your idea of putting a sunset clause on this. Commissioner Fry.
Thank you, Chair Thompson. I'm just wondering if there's some idea of, excuse me, I can't talk anymore. Commissioner Brankert's mind of what that time period would be, what that limit would be.
Well, yeah, I mean, I thought about this, and it's still going to take time for the Environment Department to evaluate the work. It would take time for the work to go out there to be done, but more importantly, it will take time for the Environment Department to come up with another set of rules, and really what we're looking at are standards here. Okay, if we're going to allow treated produced water to be used for anything, if it's, industrial uses, agricultural uses, there needs to be standards that water has to meet. And that's really what they have to come up with. They also probably have to come up with ways of testing the produced water to determine what's in it and what are the proper test protocols that are necessary. So that's going to take some time. A year seems optimistic, 2 years seems optimistic, maybe more likely. But then if you look at our process, it's taken us about 1.5 years from the petition being submitted to us reaching a decision. So I think you need to add that time onto it because the prohibition will still be in effect while the rulemaking is going on. So frankly, I was looking at like 5 years. But I'll just throw that out there.
Chair Thompson and commissioners.
Commissioner.
Please state your name.
Krista McWilliams. I guess my thought on a sunset, I think it's actually an interesting idea, but it doesn't allow us to react to the science as it's developing. And as Commissioner Harms pointed out, that we could, the environmental department has the full authority to deny an NOI if they are not convinced that we are there yet. I don't know why it would be, it feels to me like it's duplicative to have a ban for a certain period of time. You could get a few years down the road and still not have the data that you need, or you could, be behind the 8 ball and be dragging out what could be scientific breakthroughs. So those are my thoughts.
I'd like to respond to that. I agree. I completely agree. In order to develop information needed to design full-scale treatment processes, industry needs the ability to do pilot studies. You can't take work that's done in a laboratory and extrapolate it to a design of a full-scale prototype. So an idea that I have been considering is that perhaps we modify the rule to allow pilot tests, that'd be field scale pilot tests. And there are a number of pilot tests. We've heard testimony that there are a number of pilot tests in progress now, sponsored by the New Mexico Produce Water Research Consortium and others. I think the NMED's website listed 11 or 12 pilot tests. Some have been completed, some are in progress. But so my thoughts are that we would put a sunset clause in the rule, but we would develop a procedure that would allow pilot testing as well to develop that information needed for for design of prototypes, but also it would develop information on the ability of these technologies to treat the water to a particular water quality criteria. Other thoughts? Commissioner Harms.
Thank you. I think I appreciate the attempt at compromise because it sounds reasonable. But again, I'll go back to the proposed rule. It's 20.6.8.400 C1C. In there, that is a standard NMED process to ensure protection of resources. And adding a ban for a certain amount of time only complicates things. And I'm not sure that it really moves us forward. So we can be protective and do pilot studies and whatnot without a limit on the time for a ban. So it is an interesting idea. It could work. But again, I don't think it's necessary, given that the language here is pretty strong, that NMED retains the authority to stop a project that they find not protective of the environment. And it's not a general, we're going to do this project generally. They have to follow everything in the section above that describes plans for transport, safe handling, proper disposal. So you're giving all the information, and based on wherever the science is at that time, NMED can make the determination that it's not protective and stop a project. So I don't see the reason, but I do appreciate the compromise. So thank you for that.
Commissioner Zemlyak.
Thank you. And it's been a while since we had the hearing, but my recollection and from reviewing the testimony was that NMBD had identified potential loopholes in not accepting a prohibition on discharge permits for treated produced water. And, there are a number of reasons: staffing, data, expertise. And while I understand there are other mechanisms to maybe pull a project, it seems that the specific identification of these smaller scale projects was so that discharge permits, larger projects that had the potential to impact ground and surface water, didn't need to go through that permitting process, taking up agency time and resources for something that was just going to be, in their mind, there wasn't enough data to determine that would be an acceptable decision at this time. And maybe my recollection is not correct, but I think the resource question goes hand in hand with the data and the technology. Is if they're not all there, and NMED has identified that this is a step that is needed, then it seems that sunset date or extension of time lets those other holes get filled in. And there were a lot of holes in the testimony that we heard about the state of the technology, water quality, identified by the agency and other parties.
How do you want to proceed?
Is there a motion?
Yeah, I was just going to say, would we like to have a motion on whether to put a sunset time on this proposal, or is there consensus that it's a reasonable approach?
I'd like to get one more clarification from what Commissioner Harms was saying. So if we were to put, say, 5 years as rather than permanent on this role, are you saying at the end of those 5 years, any active NOIs would then lose oversight by NMED? Am I understanding you correctly?
I'm not sure what you mean by lose oversight.
Well, the rules would end in 5 years, and if there's an existing project going on with the current NOI, would that no longer be covered by NMED oversight? I may have misunderstood what you were saying, but that's what I gathered.
I covered under an NOI, the NOI is submitted and the department determines whether or not a discharge permit is required. So if there's a ban, then there would be no discharge permits. And then are you asking if at the end of the 5-year period, then we would process the NOIs? I'm not sure I understand the
No,
premise.
you said something to the effect of, what I understood, I guess maybe I misunderstood, that the NOIs, well, for what some of the proposals to the changes to the rule is that we continue to have reporting. That was one idea, have reporting from the NOIs, plus NMED had in the NOI requirements required that they get the data from the NOI. And I understood you to say at the end of the 5 years, those requirements would go away.
I don't think that's what I meant.
Okay, thank you.
And I think this is kind of leads me to my last point of it, when you introduce a temporary ban, it kind of creates complications that weren't there before. And I think that's the reason why I would say let's use the NOI process that exists, that is standard for the department, and not introduce a complication. But if we were to introduce the ban, then we would have to work out those details. And since this is the first time hearing of it, I haven't really had a chance to think about how we would actually implement that at the agency. So I apologize for that.
Commissioner Zemlik.
Just have one question to pose to all of you, because I don't think I can ask anybody out there. So this NOI process that you're talking about, if what you're proposing is there could be a discharge permit issued, doesn't that get around a public notice issue?
There is a public comment hearing a notice as part of the NOI process.
But it's different than for, isn't it different than for permits, discharge permits?
Slightly, but I can't tell you the exact details right now off the top of my head.
I think that jogs my memory a little bit as to the loophole again. And public notice is a really important thing to consider, I would think.
Yes, so I have perhaps a question on the lines of the sunset. My understanding was that this is kind of a step-by-step rule that they're working on. So if we propose a sunset, how will that impact the next steps of the rulemaking that they suggest is coming to further clarify water reuse?
Thank you. I think some of the parties suggested that a year would be sufficient to come back and go through this process from start to finish again. And I would agree with Commissioner Brankard that that's probably optimistic, but 5 years would seem to me to start the clock, the discussions, the data, and have that at a point where factoring in the time the commission needs to meet and make decisions and the rulemaking process takes at least you're narrowing down the subject matter that you're deliberating on. And so I don't know if that can be built in, before the sunset, but.
I might, Mr. Chair, and I won't do this a lot, but this might be helpful to you. My memory of Mr. Herman's testimony, I don't remember if it was Director Cross, as he was asked how long it would take to develop some standards and come back to the commission, and I believe he said 4 years. And again, that's not the rulemaking process, but that's my memory.
Thank you.
I'm sorry. Um, So there's, as I see it, there's at least two issues. One, do we put a sunset date on this? And I personally am in favor because I think there's other things that need to be addressed. We're talking about domestic wastewater reuse. We're talking about industrial reuse, and this would encourage it would encourage the Environment Department to develop those rules. The second thing is, are we dealing with NOIs or are we dealing with permits? So a discharge permit, my understanding, has a term limit. And whereas an NOI is just, a notice of intent, and my understanding is that it does not expire. That is, the NOI is issued at the beginning of the process to allow the public and the Environment Department to notice that this project is in process. So I think if a discharge permit is issued as part of this interim permit, that's a separate question. Are we going to prohibit discharge permits over the next 4 or 5 years? But again, I'm in favor of putting a sunset clause on this for several reasons. Thank you.
I have two comments. For some reason, and this may be my limited understanding of rules, when I see that word permanent, it makes me nervous that, okay, we have a rule, we can move on and ignore this, and, we've already got it in place. I like the idea of the 5-year limit to make sure the process continues to move along. And there's going to be a lot of changes in those 5 years. I think the rules can be rewritten better. And then in terms of the NOI, what was your question, Bruce? Sorry, Chair Thompson. I had a thought and I lost it.
I don't believe that an NOI has a time limit. A discharge permit has a time limit, an NOI does not.
I'm fine with the NOI, but only if there is some kind of a public notice process, which in the current rule does not. In the proposed changes, it does. And even if it's standard for NMED to have a NOI process where there is some kind of public notice, I think it needs to state it very clearly in here, because otherwise I'm nervous that there may not be a public notice.
Okay, well, let me complicate things further here. So the prohibition that I'm referring to, I don't know if maybe I'm misunderstanding what Commissioner Harms is talking about. It's the prohibition in section 400A. Okay, that's the prohibitions here. Okay. What I proposed was a sunset to the entire part, 20.6.8, put it in the duration provision. And my logic, and I didn't mention this earlier on, was that the Environment Department not only said that they were going to do additional rulemaking on produced water, but they also said they were going to do additional rulemaking on water reuse. That this is just really a minor step forward on water reuse, but there's a lot more to follow. So the deadline would trigger them to have to do both, a water reuse rule and a produced water further rules. We can make it a narrower sunset by simply having the sunset apply just to section 400A. So that it specifically applies to the prohibition on permits for produced water. We could go even further and narrow it to a prohibition on the permits for treated produced water. Because that's really the issue here. nobody's really arguing for permits on, for just pure produced water. I'm fine with a prohibition on that, forever. And I think that evidence in the record supports that. So just, that's different ways of looking at this, put this timeframe, that it could be more narrowly focused, or it could be for the whole part that we're looking at, which covers both produced water and water reuse.
Further comments? How would you like to proceed?
Can I make
Yes,
a comment,
please.
Chair? Thank you for that clarification, Commissioner Branker. Rather than submitting 1 year, an arbitrary 5 years when we think the rulemaking may be complete to lift the ban, would it make more sense to lift the ban when the rulemaking is complete? Or do you need the ban to inform the rulemaking on the science side? Just posing that out there, not.
As an advocate for sunset, I think the deadline is needed. And as an academic, deadlines are good. So are final exams. And I think we're here now. This is a good example. The Produce Water Act said that we were supposed to have rules by 2024, and it's just kind of slipped and slipped and slipped. So I would advocate for a deadline. So this seems like an issue that maybe we want to vote on. Yes, ma'am.
Chair, can I get,
Please.
I think before we vote, we should, well, maybe we need to vote on the timeline here that we're talking about. So are we talking about 1 year, 2 years, 5 years? I think that there seems to be some disagreement. 1 year seems too short and hopeful, and 5 years seems too long. So what is the sweet spot that we would be? Question is for those who propose the ban, sunset.
Esther.
I think if there's a sunset date, and correct me if I'm wrong, the department could engage in rulemaking prior to that sunset date. If it's 1 or 2 years from now, I don't think that sunset date requires 5 years of waiting. Am I wrong?
Mr. Chair, what happens next is really up to the Environment Department. Whether they want to, immediately come in with some changes, whether they want to come in a couple of years and say, can we extend that deadline a couple of years? I mean, they could come in with all sorts of different proposals. I have no prediction of what it is. This is simply to sort of spur action to actually move on this, because it's clear to all of us, I think, that we need to do further work on produced water. And it's also, I think, trying to avoid the situation where we have inadvertently approved a permanent ban that we didn't intend to be a permanent ban. And so that's sort of my logic here.
Yeah. So, I mean, we could separate the motion. We could have a motion to include a sunset clause. That would be the first motion. The second motion would be, what's the duration? Or we could just roll it into one. I think Commissioner Brankard's observation that it's taken over a year to get to this point argues against a 1 year ban, because if the Environment Department proposed a set of standards today, we probably wouldn't see it before the ban expired. So in my personal going through the regs, I suggested a 2.5 year ban. I would be comfortable with a 5 year ban. 5 year sunset clause. to be clear.
And that's on 20.6, sorry, Mr. Chair, 20.6.8.4,
4.
Section A.
There's no section.
Sorry, yes,
What's 6?
yes, that's right.
8.4.
Which way?
Yes, please.
I will move to set a sunset date of 2030, December 31st of 2030 for 20.6.8.4.
Do I hear a second? We'll
I'll
have
second.
discussion. It's been seconded by Commissioner Fry. Okay, discussion. Commissioner Harms.
Sorry, Chair, I just had a question. Is this replacing the other question on whether or not we should put a full ban on? Or is this in addition to? Will there be a follow-up? Or is this the one question that replaces that second question in the hearing officer's report?
You made the motion.
Yeah, sure. I think it answers the question, which is in part one, yes, there should be a ban, and for a set period of time of 5 years. On the use of treated produced water. Sorry, those 3 things.
Okay, further discussion. Commissioner Fry.
I feel uncomfortable seconding with that follow-up just because for me, this is simply to set a sunset clause to whatever rule we adopt. But I think we need more discussion about the rest of that.
Yes, thank you. And I was trying to clarify that I wasn't speaking generally, but then I spoke too specifically. So thank you for that.
So let me see if I understand. We are only addressing the duration of this permit. We are not addressing the subsequent sections. And the proposal is a duration that shall expire December 31st, 2030.
I am comfortable seconding that.
Okay. Further discussion. We ready to vote? Looks like we are. So all in favor of putting a sunset clause of December 31st, 2030 in section 20.6.8.4, say aye.
Hi.
Opposed?
Please let the record show that I'm abstaining from this vote.
Thank you. Okay. Yes, I think we've accomplished something. To wrap up, we have agreed that we should adopt a rule, and we have agreed that it will be a rule for a little over 5 years. So let's take a 15-minute break, and we'll resume. What time is it?
10:30.
We'll resume at 10:30. Thank you.
Yeah.
Ms. Jones, are we ready? Okay, I'd like to call the meeting, the hearing back into session. And I guess we're just a meeting, right? We've already done the hearing. So again, to reiterate, the commission has agreed that we do need to adopt some rules regarding wastewater reuse. And we have also agreed that we will put a duration on the rules that we are considering today until December 31st, 2030. So it's 5.5 years. So the next question is, again, I'm referring to the hearing officer's report. She posed, by helping to help organize the discussion, she posed 3 questions. The first was, should we adopt a rule? The second question was, if we do adopt a rule, should it include a prohibition on discharge permits for discharge of treated produced water? So I'd like to raise that second question. We have agreed to adopt a rule. Should it have a prohibition on discharge permits? Commissioner Brankard.
Well, Mr. Chairman, assuming that we've adopted a sunset on this rule, I have no problem on a 5-year prohibition on discharge permits. I think the record supports that. The uncertainty out there in terms of how to come up with the standards, how to characterize. The Environment Department emphasized that repeatedly in their testimony. And I think that supports having a short-term prohibition on discharge permits for treated produced water.
Others? I understand the concern about discharge permits. I, however, would like to see if there's a way we could allow field scale pilot projects to be tested. And one way would be to require that the treated water never leave the oil and gas industry. Never, be retained and disposed of as oil and gas waste. The problem with that, in my thinking, is that would prevent doing any testing with irrigation applications. So we heard testimony about a project in the San Juan Basin, I believe it was Canales, where they were growing crops. And it was a very small scale, but I think that's an example of a type of study that would help us develop rules in the past. So I understand the prohibition on discharge permits. I would like to see if there is a way that we could allow field studies as well. Commissioner Fry.
I'm wondering if field studies is necessary, or if, for example, a greenhouse study would contain any discharge and still be able to progress that type of research.
Yeah, or lysimeters, yes. But if we were doing a field scale project, very likely the volume of water that would be generated would require a larger application than could be done in a reasonable greenhouse. So let me just throw out a number that I was thinking of. We heard testimony about pilot projects, and there was the capacity of some of these were from 100 barrels per day to 500 barrels per day. 500 barrels per day is 15 gallons a minute. That's a lot of water. And yet I think field scale pilot studies, as I've said a couple times, are needed in order to take us to the next step, which would be design of a prototype. And also it would test the technology to determine if satisfactory water quality could be achieved.
Chair Thompson,
Commissioner.
what would prevent those types of studies being done within the oil and gas fields? So therefore, it would not require discharge off field.
But if they were testing this with a land application, they wanted to determine whether the treated produce water could be satisfactorily used for growing crops, you've automatically got a potential pathway to contaminate groundwater.
So I don't think you answered my question, or I misunderstood you. So within oil and gas,
It would
we
be-
have no jurisdiction. So if there were projects done on the oil field like this, it would not require a discharge permit from NMED. It would require no oversight from NMED. They are, as I understand it, already discharging within oil and gas. So what is the difference of just doing that type of project on there?
At present, the water is not allowed to be transferred away from the industry. If they did a field application, they would lose control of the water.
Sorry, I'm just seeking some clarification. So you're suggesting a field study where discharge would be allowed?
Yes. I mean, that's again, studies like that have been done. There was testimony before the commission. And I think that type of study is important and valuable. So I understand the sentiment towards prohibiting discharge, but I think that would prevent doing some types of studies that would provide useful information. Commissioner?
Just thinking that over.
Okay.
Yeah, I'm just pondering that for a second because we would have to make changes to the rule then that would allow for that type of study to occur, would we not?
If I had my way, we would put some type of de minimis criteria such that if there was less than a number, 100 barrels a day, it would not require a discharge permit. I don't think we can do that. So I probably just convinced myself that we should prohibit discharge permits. Wait, Commissioner Bayless.
I have a question. When in state parks, we're dealing with municipal wastewater, if it's less than 5,000 gallons a day, there's not a discharge permit required. You go to another bureau and you get a liquid waste permit, which we haven't talked about. So if that 5,000 gallons per day threshold applies to this stuff, then you have a built-in number.
Commissioner Henley.
Thank you, Chair Thompson. I just wanted to make the just distinction between discharge permit and discharging produced water. I think that in the testimony that we heard over the last year, that if sites, even if they were small, there was no intent to discharge, if there was the potential to discharge, then they are required to get a discharge permit, which is, I think, slightly different than what you've suggested. in terms of land application. And in my opinion, the Canales project didn't look like a good selling project for land application as it was. So I think if you can start off small with, and I'm sort of trying to thread the needle here with, is there a way to address potential de minimis discharge? I don't know if we're there yet. I don't know what that de minimis is. I mean, 5,000 gallons a day of untreated produced water discharge would be a really bad thing. So that's the hard thing, is that if the project is big enough that NMED will require a discharge permit, even if the applicant thinks that they're not going to discharge.
Okay, well, I think there are two issues here that your scenario has, the chairman's scenario has raised. One is the dividing line between the jurisdiction of this commission and the Oil Conservation Commission. Okay? And the second is you're sort of starting to move into the third question of permit requirements. Okay? So House Bill 546 did a valiant effort at dividing the line between the jurisdiction of this commission and the Oil Conservation Commission. But frankly, I think there will always be some gray areas. Having lived the world before House Bill 546, there was a lot of gray areas. In fact, there was basically regular meetings between OCD and Groundwater Bureau staff about what do we do with this project? Who's in charge of this? When people were coming up with ideas about produced water reuse. House Bill 546 did a very nice job, I think, of trying to divide that out. And I don't think the issue is where is the project located. I think is what is the use of the project. I think that's the way the statute reads. So even if it's Acme Oil Company planting a field of alfalfa right next to its wellhead and then using treated produced water from that field of alfalfa, that's not an oil industry use. Okay?
Yeah.
That would require an approval by the Environment Department under our regulations, even though it's Acme oil field right next to their wellhead. Okay? So I think we need to be sort of cognizant of how House Bill 546 tried to divide up the world, and it divided it up by uses. So if the use is a non-oil field use, it's under our jurisdiction and the Environment Department's jurisdiction, no matter who's doing it or where they're doing it. That's my sense of how the statute reads.
Thank you.
And then there's the permit issue, but we can get to that whenever.
Commissioner Harms, I see your fingers edging towards the.
Thank you, Chair Thompson. Commissioner Brinkert, that's how I read it as well. The Produced Water Act gives NMED authority and jurisdiction over off oil field treated produced water activities. And just to be clear, you're talking about land application in a pilot study that you're proposing?
I'm not proposing, I'm sorry, I'm not proposing anything. I'm using an example that was presented to the commission as a situation that might be beneficial, might generate useful information, and yet would not, the water would be released from jurisdiction of the, from released from ownership by the oil and gas industry.
Okay, yes, I agree with that understanding that it comes under the jurisdiction of NMED once it's released, and I think that was clearly stated in the Produced Water Act. At that point, it would follow all of our existing groundwater permitting rules and water quality standards. As far as, I thought I heard you say pilot earlier, so maybe I was going down a wrong path, but land application, that seems like a less conservative first start as opposed to using the treated produced water in a road construction project or a cementing project. Why? So you're just saying that the land application example was just because of prior hearings, not because it was the best use of a first pilot?
Yes,
Okay, thank you
yes.
for clarifying that.
But I am talking about pilot scale. So if we did a pilot scale at 100 barrels a day, 4,000, 5,000 gallons a day, that's a lot of water that could be used for other types of studies, such as land applications, such as dust control or something like that. Yes.
Sure.
Ma'am.
So if you have an ag project and you're having release, or, other pilot projects, in each of those cases, you're having monitoring of what's released, what might be getting into the aquifers, correct? In each of those cases? So that's all well and good, but we go back to the unknown unknowns. We go back to knowns that are hard to analyze. I think you can't monitor an unknown unknown. So the protections that NMED is trying to build into this would not allow that for that reason.
That's true. So you're saying that we should not allow discharge of treated produced water away from the oil and gas industry?
I'm saying that's what the attempt is to try to build into that rule, and we need to decide if we agree with that and want to add that protection.
Yeah, I just wanted to add to that. If the objective of where we're going is in the direction of standards, then I think the field scale might be jumping over a couple of steps in terms of, just determining what the standard should be, what's in the water, what the standard should be in the treated produced water. And also, this is not my area of expertise. I don't know if I'm missing something in terms of field scale application to getting towards that goal.
Yes. So the question before us is, should the rule include prohibition on discharge? On discharge permits?
I'm really good at questions today. I think so ultimately, we want those protections. We want the people ultimately having the permits to feel comfortable. And I'm wondering, what is the point where we feel comfortable? We, as in NMED, as the regulators, and we as the WQCC, as the people setting those regulations.
What, the discharge permits presumably would have fairly well-defined criteria to allow detection of adverse impacts. There'd be monitoring of different sorts. So the comfort, that's a good question. I don't have an answer.
Mr. Chairman, the reality we have to deal with is what is the proposal that's been submitted to us? Okay? The Environment Department's proposal does not entail any provisions, any specific standards for any discharge permits, right? However, if we reject their prohibition on discharge permits, it leaves open the possibility that anyone can walk in with an application for a discharge permit for any kind of use, whether it's your field scale test or whether it's, to grow 1,000 acres of alfalfa. And so the Environment Department then would have to be on a case-by-case basis, making decisions about whether to issue those permits, and if yes, what conditions would they put on those permits? So that's kind of, I think where we are. I think it's sort of beyond our ability to sort of craft a whole nother rule here about a certain type of action that's not currently in the proposal.
It's not in the proposal submitted by NMED, but discharge permits, I believe, were in the markup submitted by NMOGA.
Yes, Mr. Chairman, NMOGA wants to go to the early version of this rule where there was not a prohibition, and therefore there still is the option for people to come in on a case-by-case basis and submit discharge permit applications for, whatever they'd like for treated produced water.
Yes. Commissioner.
I just wanted to follow up with that and kind of repeat a concern of Commissioner Fry's earlier of the unknown unknowns. I mean, PFAS is a great example of what we're dealing with now and in the future. And I think if we can, given our knowledge of contaminants in ground and surface water now, think ahead to what we don't know about this water in the future, which we don't. I don't think there's been sufficient characterization to say, well, we can just deal with a discharge permit on a case-by-case basis like you would with wastewater from a municipal source or something like that.
What's the pleasure of the commission? Commissioner Laney, I'm watching your finger.
Sorry, yes, so I tend to agree with Commissioner Zimlick and Commissioner Brancard in that there isn't a standard yet that we're measuring this water against at this point in time. So it seems very premature that we would work around what was proposed and come up with an alternative for that process.
Thank you. I would remind the folks that we do have standards. We have groundwater standards, surface water standards, livestock watering standards, and I think there's a couple of others. So conceivably, if someone did apply for a discharge permit to test treated produce water on an alfalfa field, they would have to demonstrate that they're going to meet the groundwater standards. So it's not that we don't have any standards. They're not specific to treated produce water.
And I agree. I know that there's standards, but I think there's elements to this water that are outside of the standards that are already established.
So it looks like, the sense that I get is that I'm the Lone Ranger here. That everyone would like for the rule to prohibit issuances of discharge permits. Yes, ma'am.
Chair, I'm sorry, I think I want to challenge it a little bit. In response to Commissioner Frey's comment, excuse me, we're always dealing with unknown unknowns. That, I mean, we would never issue any discharge permits if we had to characterize everything. But we do have the technology we have mass spectrometry, we have gas chromatography. If you've ever been to the UNM labs and seen their equipment, it is spectacular. We do have a lot of equipment nowadays, especially in a pilot project like this, where we can dig into the science to understand what we're looking at without even knowing what was the source water. So we do have a lot of tools available to us. And if we were to just say, well, we just don't know, then nothing would ever be permitted in the state. So we're always dealing with some level of uncertainty when we issue a permit. And we do always go back to, the water quality standards that have been established, because we're still, regardless of the Produced Water Act, NMED still always enforces the Water Quality Act. And every permit is taken on a case-by-case basis. There's always a person, a technical expert or a regulator, a person with regulatory experience that sits down and looks at all of the facts, all of the science, and any permittee has to prove that they are going to be protective of the groundwater and surface water. So I don't think, not passing, I don't think we have to ban it to be protective. NMED will always protect human health and the environment. We always have that very strongly in our culture, that is our duty. So there is a person behind this evaluating every discharge permit. I just want to reassure the commission and the audience that is our goal in all of this. So putting a ban on it, in our mind, we're still going to be protective. We're still going to look at the naturally occurring radioactive materials levels, the radiation coming off of it. We're still going to do our best with the known information. So I don't want that one thing, just that you brought up, that we don't know everything, to stop us from enforcing our current laws.
How do you want to proceed? I think this is another one. I think we may need a motion. So I would entertain a motion to address the hearing officer report. Second question, should the rule include a prohibition on discharge permits for discharge of treated produced water?
I screwed up last night.
We're sort of in an impasse.
Can I make a comment before we vote again?
We haven't voted.
Or
Yes.
before we, move further. I think the state of the science presented to us this past year wasn't conclusive to a lot of us, left us with a lot of questions, data gaps, things like that. I think it is unfair to take the additional step of asking regulatory staff to examine the state of the science, presumably when it's still state of the art, as part of their regulatory duties. And I really do think that this prohibition on the discharge of treated produced water is because the standard of the science is still sort of at that state of the art stage, and the data is not a large enough body to then put into a regulator's hands to be sure that they have all of the information that they need. And I would move for the inclusion of a prohibition on discharge of treated produced water as proposed here, that includes the 5-year sunset date. And I probably screwed that up.
May I, Chair?
Yes, ma'am. Well, let's see if we get a second first.
Is there a movement? Oh,
I probably screwed the language up. So I would move to, yeah, my eyes are. I would move to include a prohibition on discharge permits for the discharge of treated produced water to ground or surface water. Yes, and the sunset date included in the
First motion.
first motion.
Mr. Chair, I assume what Commissioner Zemlik is pointing to is the current proposal at 400A4?
Yes.
Or it could be all of 400A for that matter, 1, 2, 3, 4, if you want.
Wait.
Expand your motion.
I think it's all of it.
Yes.
So, yes, to clarify, I move to accept the prohibition on discharge permits under 20.6.8.4 Part A, General Requirements.
20.6.8.400.
400.
May I make an amendment?
Yes.
That we limit that to 1, 2, 3, and 4 and not 5 yet? We ought to have further discussion on 5.
Yes.
I'd like to respond to a couple of questions. The one about knowns and unknowns, and so forth. I agree with Commissioner Harms. We are always passing regulations in all sorts of environmental programs with unknowns. I'd remind everybody that the drinking water regulations, the most stringent regulations we have for most public laws that I'm familiar with, regulate less than 100 constituents. Chemical Abstract Services lists, 750,000 different compounds. So we're regulating a very, very small subset. And yet I think we would all agree that we have very safe drinking water. Certainly the epidemiologic studies support that. The concern about produced water that has been raised during the hearings was that there were contaminants in there that were not regulated by existing standards. And that were also not removed by treatment technologies. And I counted 10 different reports that were offered as exhibits in which the quality of produced water, treated produced water, was measured. And I don't believe that we heard any testimony, I certainly don't recall it, that there were contaminants detected in these studies that could not be removed by existing technologies. There were a couple of studies done Exhibit 139 cited by Namoga. It was also cited by NMED. It was a paper by the folks at New Mexico State, an excellent paper that analyzed 40, I believe 46 produced water samples. That's a pretty large database. They did a very comprehensive analysis of both inorganics and organics and radionuclides. They even did an analysis for PFAS. In addition, this particular study that I'm referring to, it's by Delanca and Pedigi. They also looked at the toxicity. So one of the concerns is that, again, the unknown unknowns. So we do toxicity tests to determine if there are constituents that we didn't detect and quantify in our analytical methods that still exhibit toxicity. And this group, this paper, did a toxicity test, and I don't remember, I think there were 6 or 7 different toxicity tests. They were testing cell tissues, they were testing effluent toxicity to aquatic organisms. They were looking at acute toxicity, chronic. They found that the treated produced water met these criteria. So I think to claim that we don't know what's there and it's so hazardous that we have to prohibit its discharge is a statement that I disagree with. Sorry. Yes, ma'am.
Was that addressed to me? I don't think that's exactly what I was saying. I think that the worst case is that you have a discharge permit and there's a failure. And not that the treatment train works as it should and the quality standards are what they could be, but what are the potential harms if it fails? And I think the science is going in that direction, but I think it wasn't really demonstrated that, that widespread use of treated produced water is feasible beyond really the laboratory scale. And so the bench and pilot scale without a discharge permit seems like a compromise to me for further demonstration.
Chair Thompson. So I think there is, I want to say, a big difference, but I don't know that for a fact, between coming up with the drinking water standard versus regulating the release of produced water. I think that toxicity studies done on the standards, drinking water standards, that science is there. Whereas all of the NMED exhibits and testimony were saying the science is not there. Regardless of what we think about the unknown unknowns, there is also the argument that produced water is still not well characterized in terms of its chemical constituents, and therefore that's another argument not to allow the discharge.
Chair, may I respond? Thank you. If I asked someone to characterize drinking water, you would probably say from which tap? Albuquerque, Carlsbad, Denver, Colorado. The water is going to be different even though they're all considered drinking water. Likewise, the produced water from the San Juan Basin is going to be different than the produced water from the Permian Basin. The different companies may be using slightly different frac fluid, are going to be different. So I think it's a false premise that we're working off of to say, well, until it's characterized, we can't regulate it or treat it or move forward with the science. And so I would just challenge you a little bit on that premise. And I know that there are generalities that we could apply to all produced water. And I think that's where we kind of have to work within, and where there's a question, and I think NMED agrees, the science is not completely there yet. We don't have enough white papers to prove safety. In that case, I would say the notice of intent, that's part of the reason why the notice of intent is required and is sufficient to protect our resources. When you file the notice of intent, if our technical experts are not sure that way will be protective, they will stop that project. It's not going to go forward. So if the science isn't there, the projects can't move forward. And that's why I would encourage the commission that the notice of intent is sufficient because it's required here. So therefore, I'll make a closing statement just to wrap it up, is I do not think a ban on discharge permits is necessary, going back to my earlier point, because it is in the rule that they have to submit the notice of intent.
Okay. Um, so those were not my personal arguments. That was from the record from NMED, that these are the reasons why they don't want to allow discharge and have discharge permits. And they are turning to the notice of intent process. So I may not be understanding you.
Oh, I thought you said you'd not be on the same view.
What I'm wondering is, are we having the same view maybe?
Yeah, our statement of reasons at NMED did say that the state of the science is not there. And I would posit that's where that we fall to the backstop of the NOI process. If we don't feel the state of the science is ready to issue a discharge permit, it's not going to move forward. That's my point, and that's not in the statement of reasons for NMED.
Okay, so do you think we should still allow discharge permits in the current rules so that NMED can fall back on notice of intent if they don't want to allow a discharge permit?
I think that's a correct characterization, because I do not think a ban on discharge permits is needed.
So you're arguing against the motion? Okay. Are we ready to vote? Are there other comments? Okay, so we've got a motion. I don't know that I can accurately rephrase it, but it was to prohibit issuances of discharge permits under section 20.6.8.400, 1 through 4.
A1 through 4.
A1 through 4, thank you. Oh yeah, it does. A, which is general, I'm sorry. Okay, is the motion clear? Are we ready to vote? All right, excuse me. Commissioner Fry? All right, all in favor of the motion, again, to summarize, it is to not allow discharge permits. All in favor of the motion, say aye.
Aye.
All opposed, say no.
Nay.
Nay. Okay, I think we need to do a roll call vote on this, Ms. Jones, just because it's close.
State the motion one more time for me, please. Yes. Because I feel like there was some elements missing, and I'm not sure what happened to the amendment. And I wasn't sure if we needed to vote on the motion in order to have an amendment to the motion. And I'm so sorry, I wasn't using my microphone for any of that.
No, it's okay. I was going to jump in and before we voted, and I think there's a couple of things that are clarified. So the motion was on NMED's proposed 20.6.8.400 produced water reuse general requirements. That's part A, 1 through 4.
Yes.
And Commissioner Brankard had amended to not include 5. But I don't see a 5 on my copy.
5 is proposed by Namoga.
Oh, okay, I
Subsequent
see that.
pages.
Sorry. So that would be to, approve 20 points. I move to approve or to vote on 20.6.8.4, Part A 1 through 4. Jeez, okay. 20.6.8.400, Part A 1 through 4.
Can you restate the motion itself, please?
So the motion is to prohibit the discharge of produced water, untreated produced water, treated produced water, untreated produced water. Do I need to read through the whole thing? I guess. So the general requirements are the prohibition on the discharge of untreated produced water, discharge to surface water, treated produced water, discharge to surface water, untreated produced water discharged to groundwater, and treated produced water discharged to groundwater.
Is there not a 5-year sunset?
That was another one. That was earlier.
Confused. Thank you for clarifying that.
Well, it was seconded
Second, yeah.
by Commissioner Brankard.
Yeah.
And then amended but I think that, let me ask both the people that moved it and seconded it. Is it clear? Are you comfortable with the way it was stated just a moment ago by Commissioner Zemlik? I see him nodding his head. Okay, so we're ready to vote now?
Yes.
All right, Ms. Jones, would you call the roll?
I will. On Vice Chair Zemlik's motion, Commissioner Brankard, how do you vote?
Yes.
Commissioner Fry,
Yes.
Commissioner Harms,
No.
Commissioner Laney,
No.
Chair Thompson,
No.
Commissioner Bayless,
No.
Commissioner Vehil,
Yes.
Vice Chair Zemlik.
Yes.
1, 2, 3, 4, and it's 4-4. I've got 4 yeses and 4 nos.
Yes, I've been informed that if a tie vote means the motion fails. Is
Fails.
that correct,
Motion failed.
Counselor? Okay. All right.
Mr. Chair, did you have an alternative motion?
I did not. I support the idea of the Environment Department being allowed, excuse me, being allowed to issue discharge permits for pilot studies.
Okay, but you've just allowed the Environment Department to issue discharge permits for anything involving produced water, treated or untreated.
Maybe Commissioner Harms could clarify. I think you were discussing Part B, authorized applications, and not Part A. And so maybe there's a point of clarification there. I think we were talking about 2 different portions of the rule.
Doesn't have part B.
It's the, Part B is the authorized applications.
Based on my reasoning, it wouldn't really matter. But because we have those safeguards in place. Um, I don't think, it's not my belief that this means that we are going to allow untreated produced water on a land application. That's not my understanding. If that's what the vote is, then I should probably change my vote because I don't want any untreated produced water to go on a land application. So maybe I need more clarification on the implications of what this actually means. For me, the discharge permit process using our technical experts and the existing laws are at, plus the NOI process are sufficient to protect ground and surface water. And therefore, I didn't see the ban as necessary.
So to clarify, the section, the part B was for demonstration projects. And I think, again, we're talking about discharge permits. And so the way that I read the rule and the testimony that I heard is there's a discharge on treated produced water. It's part of discharge permits, but there's this authorized application section that states the way in which a demonstration project could be approved. And I don't see them as, I see them all as part of this rule and not as two separate things.
Yeah, I would agree that this is all part of one rule. And I would just, for me, putting a ban on a discharge permit, which is a core function of our agency, and it's in conflict with the Produced Water Act, which says that the department shall issue discharge permits. I trust our technical experts that they are competent and thoughtful enough to stop any unsafe, unprotective projects on this. So for me, it doesn't matter if it's a demonstration or a real project. I mean, obviously right now we're only going to be working with demonstration projects and pilot studies, but eventually it will get to a real permit application. And why would you have a demonstration for something that you have banned from happening in the first place? That's where I don't understand this.
So I think that's the idea of the sunset, right? Is that you have time to demonstrate that this is going to work. And I think to just piggyback on Commissioner Fry, the testimony we heard from the department is that it's not ready to take that next step. And so the crafting of this rule reflects that. And it seems to me that Chair Thompson's suggestion that there be some sunset date allows for the demonstration projects to sufficiently demonstrate that the applications are meeting the standards that the department thinks are reasonable before discharge permits are granted. And that's within the same amount of time that it took us to get from zero produced water talk outside of oil and gas to now, which is a little more than 5 years. 5 years to get to a place where you can have some agreed upon standard. And again, I'm just, this is the technical testimony that we heard from the department.
Chair Thompson. I'd like to investigate more the discussion of permits versus notice of intent. During testimony, the folks from NMED, I thought were very clear that no notice of intent would be allowed if whoever's doing the work were going to discharge any treated or untreated water. I notice it doesn't state it, or at least just a quick scan, it's not stating that specifically here in section C that goes over notice of intent. So if we were going to support that what the intent that came through in the testimony, then we would need to state that specifically, I think, in notice of intent. If we were to remove, now I can't find it, the section A, which prohibits discharge to surface or groundwater. So I'm wondering, Commissioner Harms, if you could talk more about your thought of allowing permits and allowing NOI in the same rule.
Thank you, Commissioner Frey. The notice of intent is the first step in the discharge permit process. And my understanding is once if a permit application, or sorry, if a notice of intent is filed and the department, based on their technical expertise, determines that it's not protective, it will stop. If they determine that it is protective, then it goes into the discharge permit program and it is further evaluated, further scrutinized, and yes, it will take years to get that discharge permit moved forward. And that's where I don't see a purpose to, you know, we have banned it for 5 years, but I don't see this as a necessary indefinite ban. I just don't see this as necessary. It adds complication and to the process, and I would rather work within our standard processes for protection of resources. The Produced Water Act, I keep coming back to this, states that NMED shall be issuing these permits. And so I see this, a ban on this, as being counterintuitive to that and counter to what was intended. And I don't want to be put in that legal gray area.
I pose a question. If what we heard from the department last summer, along the lines of not being ready, they don't have the data, they don't have the technology, but you allow for applications to come in. To me, as a regulator, that seems like you are receiving applications and they sit there for a period of years until you're ready to evaluate them. And if really the goal, and to say this again, if the goal is to get to a standard, then shelving a bunch of projects until you're able to fully evaluate them, or alternatively, not having the capacity to fully evaluate them and allowing them to go forward, neither one is really achieving that standard that we don't have, that's at a point in the future. And as I read it now, what it's saying is in a limited capacity, you can demonstrate, you can do what, you can produce the quality of water that you think you can, and you can use it for these purposes, and then we can revisit it. I would just pose that question is, if you don't have the capacity now, but you allow for it now, what does that mean for applicants? It seems like limbo to me.
It's a fair question, Commissioners. I'm like, we're not allowing it if we don't know. So our NOI process is in place in section C of this so that they can stop it. Our team can stop a project that is not safe for the environment. So for me, I wouldn't say that we're allowing something when there's a process in place, a formal process in place to stop it.
Sorry, I just have one more comment, and it's just to reiterate from the testimony that we heard, and I think the order in which this rule is presented, what I heard from the technical experts is we really do not want to address discharge of treated and untreated produced water at this time because the science is there, the data is not there. Section B says, but here's how you could use it. These are demonstration applications. These are where we would find it acceptable, and C, this is how you would go about getting that accomplished. And what I hear from you is that it's sort of the opposite, which is, you know, you don't need a prohibition, you can just go to the notice of intent. But I think that the prohibition, like Commissioner Brankard said, includes prohibition on untreated waters as well as treated waters. And so I just wanted to make that clarification as that's how I'm reading it as set forth by the department.
Commissioner.
Yes, I would agree with that interpretation. That's how I understood it as well, which would suggest that then if someone applied for a permit, they would just sit and wait until the technology caught up, and that's an unknown period of time. The last motion didn't include the sunset, so that's where I kind of fell off. I like the idea that there is a known point in time which we can come back and see things, have further rulemaking, that it's not a permanent. So I just wanted to clarify there. And state.
Yeah, let me just add a point. We already passed a sunset clause. That was 20.6.8.4. So this discussion, the motion that we just addressed was not relevant to the sunset because that's the whole rule is will sunset in 5.5 years. But Commissioner Brankart asked me a really good question. He said, do I have a substitute motion? And he makes a point, and it's a good point, that by allowing discharge permits, in principle, we could allow someone could apply for a discharge permit for a full-scale application of 100,000 barrels a day. And that was, we're not ready for that. So my intent on when I reviewed this section was I was thinking in terms of demonstration project, pilot scale demonstration projects. And so in a moment after we've discussed that, I would like to make a substitute motion that section 20.6.8.400, the permits would only apply to pilot scale projects. Is that clear? And I'm not making the motion yet, but that's what I'd like to put out on the table.
So, Mr. Chairman, this would essentially be, you'd start out with a proposal for a pilot project, you file an NOI, and if the department determined that you're required to get a discharge permit, then you get a discharge permit under your proposal.
Yes. Yes, if it meets the criteria that justifies a discharge permit.
Okay, so in other words, the proposal submitted by the Environment Department said, you file an NOI. If the NOI process determines that there's going to be a discharge, you're out of luck because we're not issuing discharge permits. Your proposal would be, you are in luck, but you need to go get a discharge permit.
Yes. But it would only be allowed for pilot projects. Thoughts? Dr. Zimwick.
I was just looking at the definition of a pilot project. And I think it came up during the hearing about what size
Yes.
and
It's not specific.
but it does have the advantage of being more providing a more narrow target than discharge permit.
Yes.
Is it?
Yes. And I was going to bring this up later, but I will bring it up now. I think we ought to put a limit on what constitutes a pilot study. And yes.
You do have one party who proposed expressly a limit. That was NEE.
Is that in your report?
It's on page 15, CGFCM and NEE.
And that is a limit of, and I had found that as well. That is a limit of 2,000 barrels per day, which is a pretty good sized plant. That's 80,000 gallons a day. So look, trying to structure this conversation. if I, would the commission entertain, would be, no, I'll just might make it as a motion. The section 20.6.8.400 would discharge would be allowed for treated produced water to surface water or groundwater only from pilot projects. That's my motion.
Can I suggest an amendment?
Please.
I think we're talking about discharge permit, not their
Well, it says discharge
to,
it would require a
Yeah.
permit, yes. But I'm suggesting that it be allowed that to surface, treated produced water could be discharged to surface water or groundwater, but it would require an appropriate permit. Is that sufficient clarification?
yes.
Yes, ma'am.
Mr. Chair, if I might, perhaps your council could advise on how specific you would need to get in terms of proposing language to the different sections, because the commission can vote, or reach consensus on a general idea, but ultimately, I think, I mean, I would think, because I don't know who would draft it otherwise, that you're going to have to be specific about language in different sections.
So are you suggesting I make a suggested language? I could do that. I think it's pretty simple.
Okay, that's what I'm suggesting.
Okay, so my amended motion, again, this deals with 20.6.8.400. It states the following provisions apply to discharge of produced water. And I would say discharge of produced water from pilot plants. So the 20.6.8.400 would say produce water reuse as provided in the Produce Water Act. The following provisions apply to the discharge of produced water from pilot projects for activities unrelated to exploration, drilling, production, treatment, or refinement of oil or gas. I would just substitute from pilot projects.
Chair
Commissioner.
Thompson. 20.6.8.400 also covers the notice of intent process, which includes other projects. So rather than making the change at the top level, I'm wondering if it would be better to make it at section B, authorized applications.
I think the language at the top covers everything below.
That's what I'm saying.
So I want to put it in the first sentence.
So does that in effect disallow notice of intent on other projects is what I'm asking.
I don't think so. I don't think so. By stating it's water, treated, produced water, discharge for other uses. I think that covers what's in the notices of intent.
So Chair Thompson, you're suggesting an amendment to this first 20.6.8.400 language here.
Yes.
Is that an issue though? Because that's under the Oil and Gas Act. It says as provided under the Oil and Gas Act, but we're then now breaking part away from the Oil and Gas Act. So it might make more sense to have a general requirement, whether it's treated produced water discharged to surface water. So sections, parts 2 and 4 include treated produced water discharges. And perhaps, I don't know, the way that I'm reading that is that maybe the pilot projects should be exempted there. Non-attorney eyes.
What? No, I think that's a really good point. And in my markup, I should have read it from my markup instead of from the screen. Let me change my amended language, and I think this will address it. What I have said in my markup, as provided in the Water Quality Act, subsection P of section 74-6-4 NMSA, and the Produced Water Act, subsection B of section 70.70-13-3 NMSA. Following provisions apply to discharge of produced water from pilot plants for activities unrelated to the exploration, drilling, production, treatment, or refinery. So that would address both acts.
2 inclusions of language, 1 for the water quality, what?
Turn on your.
Yes, sorry about that. So 2 inclusions, 1 at the beginning of the statement and then another. Okay.
Yes, and it would clarify that these discharges are subject to both the Water Quality Act and the
Produced water. Oil and Gas Act,
Yeah,
which
the Oil and Gas
references
Act.
7013-3. Okay.
Thank you. Is it clear now?
Chair Thompson. So you're still proposing that change in the first paragraph, which I may just be misunderstanding your proposed change, but it sounds like you're only allowing pilot plant studies. So what happens to benchtop studies that want to continue that NMED might like to be covered under the notice of intent process? You're disallowing that, if I understand.
It's my understanding benchtop studies, laboratory studies don't require any permits.
But they're wanting to have notice of intent. And I support that. They want to be able to collect that data.
I don't see anything in the notice of intent that refers to bench studies.
Mr. Chair, the rule deals with demonstration projects. Demonstration projects include pilot projects and bench scale projects. So maybe you would be better off just sticking with the term demonstration project.
My markup just says demonstration projects means a pilot project. You need to. My markup just refers to demonstration projects. pilot demonstration. It says, means, oh, I see. Yes,
We need to make sure we're working from the. It seems like the commission may be referring to the December petition version, which is department's amended petition.
thank you. I think you're right.
So, Mr. Chair, the definition proposed for demonstration project is on page 6 of the walkthrough document, my attachment A. Demonstration project means a bench scale or pilot project as defined in this part. Then NMOGA proposed to delete bench scale. But again, the department's proposal included bench scale and pilot.
Yes, my markup also deleted bench scale, so I didn't see it. So we're, okay. So I've got a motion. For now, we could list it as demonstration projects. When we get the definitions, I want to strike bench scale projects from the NOI. All right, so I'll rephrase my motion one more time. Not sure it's going to pass, so I'm used to that. Where is it? Here it is. I'm sorry. So my motion is to word 20.6.8.400 produce water reuse. The language that I am proposing as provided in the Water Quality Act, subsection P of section 74-6-4 NMSA, and the Produce Water Act, subsection B of section 70-13-3 NMSA. The following provisions apply to the discharge of produce water from demonstration projects for activities unrelated to the exploration, drilling, production, treatment, or refinement of oil or gas. Does that make sense?
Could you continue with the rest?
I'm sorry?
That's all.
That's it. So what I've done is two things. I've added the Water Quality Act, reference to the Water Quality Act, which governs discharge permits. And I have, as well as certification of NPDES permits, and I have qualified the discharge to be allowed only for discharge from demonstration projects. And the motion dies for a second.
Sorry, but could you read your language again?
One more time.
Yes, thank you.
20.6.8.400 produce water reuse as provided in the Water Quality Act, subsection P of section 74-6-4 NMSA, and the Produced Water Act, subsection B of section 70-13-3 NMSA 1978. The following provisions apply to the discharge of produced water. Here's the key language: from demonstration projects for activities unrelated to the exploration, drilling, production, treatment, or refinery of oil or gas. Okay, so I've done two things. Again, I've added reference to the Water Quality Act, and I've constrained it so that we allow discharge only from demonstration projects.
Mr. Chairman? We have already eliminated 400A. So therefore, we've allowed all uses of produced water to get a discharge permit.
Is that true? No, I'm sorry. My question is, did we eliminate 400A? Or we were just referring to the requirement for discharge permits? And I would remind you, the motion failed.
The motion to adopt 400A 1 through 4 failed. So at this point, we have not adopted 400A.
So, Mr. Chair, if, not to presume, but I guess my question of you would be whether it would make more sense, as a commissioner earlier mentioned, to focus on what you'd like to authorize in section B rather than putting the demonstration project authority at the very front of section 400.
Mr. Chairman, would you like me to offer an alternative?
Yes.
Okay. How about if we go back to sections A 1 through 4, except at the beginning of subsection 4, write the words, as sectors provided in subsection B, blah, 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 400, okay? And then in subsection B, started out with, and we can discuss the industrial projects later, but let's just leave that off the table for now.
Yes.
Say demonstration projects shall require a discharge permit unless determined by the department not to require a discharge permit because blah, blah, blah. And actually, let me amend that because there's a whole problem with demonstration project. The definitions of demonstration projects, pilot projects, whatever, never mentions the word produced water.
Right.
Okay. So I would start that actually by saying demonstration projects that involve treated produced water may obtain a discharge permit unless determined under an NOI process to not have to get a discharge permit. And Commission Counsel, we're sure hoping you'll clean all this up
Yes.
before you file it.
Look, it's 5 minutes to 12. I'm increasingly confused. Let's take a break for lunch and come back at 1 o'clock.
And is there a way to get you the current version that we're discussing, not the December version?
I've got it.
Oh, you got it? Okay.
Yeah.
We don't want them December version, we want the May version.
Right.
Original January.
Do you need a copy of some?
No,
I can have
no,
it.
she wanted it.
Because my attachment A is definitely.
Yeah. Yeah, I've got it. I'm also looking at this.
Yeah.
I'm looking at
Reshuffling.
Namoga. Should probably throw her in there.
There are then versions.
This is really confusing.
That's why I got confused.
Sit down, we'll restart the meeting. Okay, are we ready to go? Thank you. So welcome back to the afternoon. It's Tuesday, the 8th of April. We're reconvening our meeting to discuss WQCC 23-84. It's the wastewater reuse rule. To bring everybody up to date, what we have accomplished so far is we have put a limit on the duration of the proposed rule. This is section 20.6.8.4, which is the duration. And originally it was proposed that it would not have an expiration date. We voted that it would have an expiration date December 31st, 2030. So that's 5.5 years from now. We've talked about other things. We have gone to, as we talked earlier this morning, the hearing officer's report suggested there were 3 questions to be addressed by the commission. The first was, are we prepared to pass the rule? The second, and we all agreed in the affirmative, the second was, would we require issuances of discharge permits for wastewater that was discharged outside of the oil and gas industry? And that is covered in section 20.6.8.400, which is produced water reuse. And so that's where we finished our discussion. We had a motion to have a categorical prohibition of all discharge of water outside of the oil and gas industry. That the vote was 4-4, and a tie vote means that the motion did not pass. So the proposed rule, and I'm working, I think, from the May 6th,
The May amended
the
petition.
May amended petition. And that is, again, I'll have to find it, but yes, sir.
Exhibit 175, and there are important differences between that and the petition version, or I should say, either of the petition versions.
And also to piggyback there on Mr. Knight's statement, attachment A to the hearing officer report and all references in the hearing officer report are to Exhibit 175. But that is the one that I proposed you walk through.
Thank you. And I appreciate that clarification because there are so many different proposals that it helps. Okay, so we are discussing section 20.6.8.400, which is produced water reuse. And I had made a suggestion I had made a motion, but it never got a second. But the motion was that the first sentence for 20.6.8.400 would be modified in 2 ways. First of all, it would reference the Water Quality Act. And secondly, it would say that discharge of produced water from demonstration projects would be allowed. And those would require, in principle, they would require a discharge permit, either a surface water discharge permit, an NPDES permit, or a groundwater discharge permit. So that's pretty much brings us up to where we were at 11:55, and then Commissioner Brancard threw a wrench in the works. And I was hoping that he might have some thoughts on how to resolve it. Mr. Commissioner Brancard's made the observation that by having the motion to disallow discharge outside of the oil and gas industry essentially eliminated Section A. So they would have eliminated the language 20.6.8.400A, which was general requirements. And so I think that brings us up to where we are now. And if I've missed anything, please feel free to correct me. Okay. So now we go to the uncomfortable silence. How do you want to proceed? First of all, let me ask the commission, how do my proposal was that we allow discharge for small scale. Let me rephrase that. We allow discharge from pilot projects. And my justification was one of the questions that to be answered is, are there environmental impacts for use of treated produced water for land application, irrigation? And I think to do those types of studies, it may require applying treated produced water to an alfalfa crop or something like that at scale, at a bigger scale than what you could do in a greenhouse or something, or a lysimeter. So that was the justification. But I'd like to hear the commission's thoughts on whether that is something that we want to include in the proposed rule, in the final rule. Okay,
Chair Thompson?
ma'am.
So you're talking about the pilot study, or excuse me, the demonstration aspect of this and making an amendment. I would suggest that we keep it simple and to what we originally came here to do, and not add pilot language to anything at this point. I think that we should stick to the roadmap questions and just to be clear on, what we're proposed, and not go outside of this, because I think if we confuse it with, well, we proposed this, but it's going to sunset in 5 years, and now we're going to add a pilot clause on here, I think we're losing track of what we're voting on. And I would suggest we just stick to what we have here, and which has a lot to do with the discharge permit system of NMED, which I don't think has been made very clear. The NOI, as written in the Produced Water Act, allows NMED to stop a project, not just determine whether or not a discharge is allowable, but it allows us to stop a project. And we're not rubber stamping anything. If we allow a discharge permit application to be submitted, that doesn't mean we're rubber stamping it and allowing a discharge. That means that the application is going to be analyzed by our technical teams, and they're going to look at the science, and they're going to take into account all of the safety protocols, the Water Quality Act rules that apply to ensure that it's safe. If it's not safe and protective of our natural resources, then we don't issue that permit. It doesn't go forward. So we already have the backstops in place. When we introduce bans or pilot or conditional wording to this, it kind of lends to the idea that our current processes, our standard processes for NOIs and DPs is not sufficient. And I would argue that it is both sufficient and required of this process to move forward.
Further comments? Commissioner Brinkhardt.
Mr. Chairman and Commissioner Harms, I guess I would disagree because the legislature has clearly directed us to adopt regulations about produced water discharge, handling, transport, storage, recycling, or treatment. So presumably the legislature thinks that we ought to be doing something other than what's normally gone on for permits by the Commission and the Environment Department.
Yes, I agree with that. I'm sorry if it sounded like I didn't agree with that. The Produced Water Act gives us the authority to manage or to regulate the oil field processes, as you mentioned, and that's why I'm arguing against a ban on the discharge permitting.
Okay. One thing that's not clear to me, I think, Commissioner Harms, you've conflated NOI and discharge permit. My understanding is that a notice of intent is simply a notice of intent to do a project. And I don't know, I don't see anything in the language that requires permission from the department.
So I'm in the old version that I've printed, I'm referencing, it is 20.6.8.400, Part C, 1C. And it says, if the demonstration project does not meet the requirements in this section above, or if a discharge permit is required, the person shall not implement the demonstration project as proposed. And that's in the end, the section under notice of intent. So you're correct. They are different processes, and usually, I think the way most people are used to seeing the notice of intent is it's a notice, and then the department issues a discharge permit required or discharge permit not required determination. In this case, the way it's written, we actually have the authority to stop the project. So not just determine whether or not a discharge permit application would apply, but it also allows us to stop the project if it's deemed not protective of the environment. Did that clarify it, or did it confuse
That
it?
does.
Okay.
I'm not sure where the authority would be granted. It says the person shall not implement the project. Is there authority given to the department to prevent that?
I guess that's in the rulemaking in front of me that we're approving today.
Okay.
It does say in the sentence above that the department shall make a determination if the demonstration project meets the requirements in this section. So that, to me, it sounds like they have the authority to allow or disallow.
Okay. Commissioner Zemlich.
I'm sorry, I'm a little confused because, and this may just be because we're looking, thank you, Chair Thompson, sorry. Because we're looking at different versions, but again, as I'm reading this rule, it first lays out the prohibitions. Then it says, these are the instances where you can use treated produced water. And then the third section is here to go about using it. And I don't see where it allows the granting of discharge permits after that prohibition in the first section. I guess I'll reword this conceptually. How would the department, if there is a prohibition on use, discharge outside of the oil and gas industry, then be able to use the NOI as a vehicle to grant a permit?
It's NOIs do not grant an ability to discharge or an ability to get a DP. The DP is a separate process that's evaluated in addition to after the NOI. So maybe I need to ask Chair Thompson again, the amendment. Are you saying that your amendment would only discharge or would only require a discharge permit if it's applied, say on a land application?
Yes,
Okay.
yes. I mean, the way the rule is written now, discharge is prohibited. And I'm suggesting that I think that there should be some flexibility to allow small scale discharge under very carefully controlled and regulated circumstances. But I think that type of information, it will generate information that is needed for final rulemaking.
And I would support that. Thank you for clarification.
If I may, I think it's beneficial if we're going to consider that, Chair Thompson, not to kind of bury that under the third section. I think it needs to be, as you've proposed in section A, the exemption, because if it's sort of like, well, we're not going to allow for any of this. Here's if you want to do it, then you can do it this way. And here's the process which allows for a loophole to get around part A. I just think it would be more clear if there was another bullet specifying exactly what that use would be. Thank you.
Just to get back to your motion, because there is an NOI process in place within this rule currently, why exactly, well, you want the permit to allow them to discharge, possibly for agriculture. I just answered my own question.
You know, this is a tough issue. I want to encourage the commission to resolve this because I think of all the provisions in the proposed rule, this is probably the most challenging, most consequential. Commissioner Zemlin?
I'll hold my. Bill, did you have a comment?
I would disagree. I think the definitions are going to be much more challenging.
Thanks for the encouragement.
And so, but I guess I'm kind of confused here. Not unexpected. That is your proposal, Mr. Chairman, to allow discharge permits only for pilot projects? Or is it to allow discharge permits for any use of treated or untreated produced water?
My proposal would be to allow use of treated produced water outside of the oil and gas industry from pilot projects. And so perhaps it would be an industrial use, water cooling or something like that, or land application as we talked about, or conceivably some other type of use, but I wouldn't restrict it just to land application.
Okay, but but if somebody comes in and says, well, the heck with the pilot project, I'm just gonna plant 500 acres of alfalfa and pour untreated produced water out there for irrigation.
No.
What's the problem?
No,
Well, what have you done to prevent that?
treated produced water, first of all, and then it would be subject to a discharge permit.
Right, but they could still apply for it. They could apply for any use of treated or untreated produced water without a prohibition.
But applying for it doesn't mean it's going to be approved and permitted.
Well, maybe now, but 2 years from now, we'll have a new governor.
And furthermore, we're talking about from a pilot project, so it's pretty small volumes.
Again, Mr. Chairman, you're talking about pilot projects. I'm saying that right now, we're at a position where anybody can apply for anything with produced water for a discharge permit.
Yes, but I'm saying we write into the rule that it's constrained to pilot projects.
Okay, that's what I was trying to get at with what I proposed right before lunch, and everybody was too brain heavy to get there. That's what I was proposing, to keep A1 through 4, but have an exception for pilot projects, either as NOI, no discharge, or as a discharge permit.
Commissioner Lane.
I was just going to ask that he restate what he was proposing before lunch, but you did so thank you.
I wrote it down.
Good.
So, let me ask a real quick question. So then what you're proposing would maybe be another point under A. It would be a fifth point.
I think what I mentioned was that under A4, which is the treated produced water discharge to groundwater, we say, except as provided in subsection B, okay? And then in subsection B, refer to demonstration projects either requiring a discharge permit or as determined by the department to not require a discharge permit because they had through the NOI process.
You added that involved treated produced water.
That involved, yeah, because the definition of demonstration project doesn't include those words.
And that would be number 10 under B then?
No, it would be right there in the first paragraph, right at the beginning of B. And I would call B authorized, well, forget it.
So Commissioner Brancard, are you prepared to make a motion to that effect?
Well, Mr. Chair, I just want to make sure that this is what you intend.
Again, my intent is to limit this to small volumes of water. And I think by limiting it to pilot projects, possibly demonstration projects, I'm concerned about demonstration, but as long as we agree and the rules has some provisions to limit the size of these projects, I would agree with your suggestion.
Would you like me to move forward there?
I would be delighted.
Okay, so I propose that we bring back from the dead section 400A 1 through 4. Okay, with the following amendment at the beginning of A4 saying, except as provided in 400B, and up to meet the State Records Center wording on that. And then at the beginning of 400B, after authorized uses, we can say demonstration projects may obtain a discharge permit or if determined by the department, et cetera. Now, I will leave that open if we want to further clarify what the word is demonstration project or pilot project. That's nothing to indicate whether we should put a limit on size of it, but that's just to clarify where we are on 400A and B.
That was a motion?
Yes, that was a motion.
Second.
I like that. Is there discussion? Is everybody clear what we're doing?
I have one question.
Mhm.
Why not clarify that definition right now? Just so we know exactly what's being put into the record.
I'd prefer to do one thing at a time.
Sorry, just to understand that definition being the definition for pilot project? Or
Demonstration project.
Okay, thank you. I wasn't clear which
'Cause
definition we were referring
Let's
to.
just verify one more time. It's demonstration project that's on the table right now, not specifically pilot projects.
Yes.
Okay.
Thank you.
Further discussion?
Not to further complicate matters, but it's demonstration projects and industrial projects. So are we adding pilot to it? Are we combining it? Industrial. You may want to limit discharge permits to the pilot scale, and then applications not requiring a discharge permit could potentially be larger, but there are those three firms now that we're talking about.
Well, I will leave the demonstration project, pilot project, bench scale project to the chair to work out what he is intending. As for industrial projects, that's another debate.
So you don't want to exclude industrial projects in your motion now?
I'm just not going to address it right now. Yeah.
Sorry, I have a thought here. Let me just get to my section. One more page, almost there. Okay, apologies. So the definition for demonstration project is bench scale and pilot projects as defined in this part. So we've effectively, demonstration projects is bench scale and pilot. Is that the correct, I'm reading that in the rule, is that the correct interpretation?
As compared, those are lumped together and industrial is separate. I'm fine with that distinction. Or definition.
Yes, that's just how it's defined currently. So if we keep with that definition, then it does put bench scale and pilot in the same definition under a demonstration project.
Yeah. Okay.
Chair Thompson, I guess I would continue to argue for settling on what we want to do with the term demonstration project, because that could have some bearing on how people decide with this motion.
And just to be clear to that, in your, the notion here is that for, was it pilot project? I don't recall earlier, there was a discussion of the volume of water that would be applicable based off of a recommendation. Is that what you're getting at?
So we had clarified that Chair Thompson was wanting to make the motion with demonstration project based on the definition that includes bench scale and pilot.
Okay, further discussion? Are we ready to vote or you want?
Mr. Chair, I go along with my fellow commissioner here that my assumption of voting yes on this is based on the assumption that you will be limiting the size of these demonstration projects further.
Yes. Yes. And kind of jumping ahead to definitions, I would like to remove demonstration and change that to pilot projects. Because demonstration is open-ended. That could be very large, it could be very small. So with the definitions in a minute. Commissioner Fry. If you would prefer, Commissioner Brankard, we could set this motion aside and go back to definitions. Of a demonstration project.
I have a question.
Oh,
Yes, I'm sorry.
Mr. Chair, you're the chair.
I don't think this is going to help the conversation any, but all three of those are defined. So are we going to set parameters around all three of those different sizes of, so bench scale project is defined, of course, demonstration is defined, pilot project and industrial are all defined. Are we setting parameters around each one of those so that we have an understanding of the volume of produced water that may be associated with those projects?
I don't know. Commissioner Brankard made the motion.
Mr. Chair, I don't quite know where you're headed with the pilot projects and demonstration projects, but I'll leave that up to you.
Okay, well, there was testimony provided by New Energy Economy that a pilot scale project would be 2,000 barrels or less per day. Personally, I think that's a little high, but I would accept something on that order of magnitude. Recognizing that a full-scale plant might treat 100,000 or maybe even 1,000,000 barrels a day. So this would be much smaller scale.
Okay, but did you have a particular problem with bench scale projects?
Yeah, but you're all lumped under demonstration projects for now, so.
Bench does specify that it's in the lab. I think so we can kind of rule that one out, right? Because it doesn't matter if it's in a lab, there's no discharge permit required. It's outside of that setting, isn't it, that we're kind of worried about here? And that way it doesn't interfere with lab activities and research that's already covered under a permit or what have you.
Commissioner Laney.
Yes, so I agree. If we're going to change the definition, we might not want to we might not want to vote on the motion right this second because it does include the language for demonstration projects. So if we're wanting to change that to some degree, we might want to make those changes and then we would have a better understanding of the scale of what we're looking at for the motion that we're currently considering. I would agree.
Commissioner Brankard, would you agree to set this motion aside until we have further discussion of what constitutes a demonstration project?
Absolutely.
May I add? With the clarification from Commissioner Zemlich, I would propose that we just make it for pilot projects then and leave demonstration projects out. And that way, I think we could set it, to me, that would satisfy me to move ahead with the motion.
I second that.
Which was my first proposal. We've gone full circle.
Just takes us a little longer to get there.
We had to have the discussion of the definitions
I
first.
understand ideas need adjusting. Okay, so I think that was offered perhaps as a friendly amendment to Commissioner Brankardt's proposal.
Okay, if I understand what you're proposing, Commissioner, is that the only things that will be allowed under a discharge permit as opposed to an NOI will be a pilot project.
Yes.
Okay, that's a friendly amendment.
We're getting close, I think. What's the sense of the commission? Do we understand? Commissioner Brankard, one more time, could you restate your motion and then we'll vote on it, I think.
My motion is that the commission adopt section 400A 1 through 4 with the following change to A4, which is the beginning of A4 would be except as provided in 400B, comma, no person. And at the beginning of 400B, it would say, pilot projects may be allowed under a discharge permit. And then it would say, or demonstration projects or industrial projects determined by the department to not require a discharge permit.
All of this involves only treated produced water, right?
Yes, so yes, that language that I had mentioned earlier and I forgot to put in here. So it would be pilot projects that, what was the word I used? That involve treated produced water.
Okay, is everybody clear?
Did we have a second?
No.
I second.
I was gonna say.
You made a motion, second, and you made a motion to add.
No, I think it's just an amendment. And you seconded, I'm sorry. I'd forgotten. Are you ready to vote? Ms. Jones, let's do a roll call vote. Roll call.
To be clear, this is Commissioner Brankard's motion, seconded by Commissioner Laney. Did I get that right? Okay. Commissioner Brankard, how do you vote?
Yes.
Commissioner Fry,
Yes.
Commissioner Harms,
Yes.
Commissioner Laney,
Yes.
Chair Thompson,
Yes.
Commissioner Bayless,
Yes.
Commissioner Vehil,
Yes.
Vice Chair Zemlik.
Yes.
Chair Thompson, the motion passes.
Thank you. And thank you to the commission. This is progress. Okay. So let me ask, are we now done with section 400?
Mr. Chairman, I think we may be done with question number 2.
That was going to be my follow-up, yes. So again, to remind the commission and folks in the audience, the hearing officer suggested 3 questions before the commission. The first one was, should we adopt a rule? Second one was, should the rule prohibit discharge permits for surface or groundwater, to surface or groundwater? And we're talking about discharge of treated produced water. We're not talking about untreated produced water. I think everybody in the state agrees that that should not be allowed. And then the third question was, do we require discharge permits for these discharges, or is an NOI sufficient? And so Commissioner Brankard suggests that we've dealt with that question. Is there any discussion on that possibility, that third question? Again, to just repeat what the hearing officer suggested in her language, if the commission allows for demonstration or industrial projects with produced water, must a discharge permit be required, or is the NOI process sufficient? Comments, questions?
Yes, Chair Thompson, just to clarify, the NOI process is sufficient so long as there's no discharge permit issued,
Yes.
correct?
Yeah. Or no discharge proposed.
Yes.
Yes. Okay. All right.
Now we go to attachment A.
attachment, which is the markups.
Yeah.
Okay. Yes. The hearing officer has reminded me, our next step is to go to attachment A, which is the proposed markups by each of the different participants. And I don't have that one up yet.
I'm sorry, Mr. Chairman, did we deal with question number 3?
Just now.
So that's what Chair Thompson was asking. Was there any part of question 3 that hadn't been resolved in the motion that was unanimously approved just a few moments ago? And when Commissioner Zemlik clarified that the NOI was for those projects and Commissioner Fry as well, for those projects where no discharge was proposed or authorized. No one suggested that there was some remnant of question 3 that still needed to be answered.
I missed that. I missed that. I thought we were still on question 2 when you asked that question. I do have a real concern with question 3. Okay, and the issue with question 3 is, what is the role of the requirement in the Produced Water Act for permits to the permitting process that's being proposed here? Okay, the Environment Department has taken a position that this process is completely governed under the Water Quality Act discharge permitting process, right? And the problem is that we have a provision in the Produced Water Act that requires the Department of Environment to issue permits. And it's permits before using the produced water, not discharging the produced water. And so the question is that in any way a different scope than what the Water Quality Act requirement for discharge permits are? The Environment Department takes the position that somehow the Produced Water Act is subordinate to the Water Quality Act. Sure how one statute is subordinate to another, but I would say that the Produced Water Act is giving kind of a broader authority and responsibility to this commission and the Environment Department about regulating produced water, not just when it is potentially discharging, but even in the amendments to the Water Quality Act, it refers to discharge, but then it says discharge handling, transport, storage, recycling, or treatment. So there's a number of activities related to produced water that we are supposed to be regulating here. And some of those can obviously be included in a discharge permit. Environment Department is very good at that, say, when it's dealing with a copper mine. But I think it's almost from leaving the oil patch to disposal regulation of produced water that I think we are expected to do. And I bring this up in particular with one specific instance, one specific issue in the proposed rule, and that is the proposal for NOIs for industrial projects. I think what the Environment Department is sort of hinting at, although frankly, the record is pretty sparse when it comes to what are these industrial projects, what do they involve. They seem to be sort of assuming that we're talking about a closed loop industrial project. In other words, the water simply goes through the facility and comes out the end and you dispose of it and never touches the ground, et cetera. So therefore, it's not a discharge, and therefore you don't need a discharge permit. But from my reading the language of the Produced Water Act, that appears to be a use of produced water. You're using it in an industrial project. Okay? And so it seems to me that you need some sort of permit for that, you know? And frankly, where did that produced water come from? How is it treated? You know, how is it being handled? How is it being stored? All those things would need to be in a permit, which would have to go through, you know, some sort of public process. You know, if the idea is to use, say, the permitting process that's associated with discharge permits, fine. There's a whole public process that goes with that, et cetera, public notice, hearing, opportunity. The environmental could sort of piggyback on that process. But I think the scope of the permitting is set by the Produced Water Act. And frankly, the language that's in the Water Quality Act, that it's broader than simply, is there a discharge that could impact groundwater or surface water? So I would propose that all references to industrial projects be eliminated from the NOI, which is not a permitting process per se. So the 400B and C, that all references to industrial projects be removed. It may not be that difficult for the Environment Department to come back with a rule, because if it's a closed loop process, might be pretty easy to come up with a permitting process, but it would still have to be a permitting process that would go through everything that a permitting process has to go through. I could go on further about this, but I won't.
No, I think this is a very, very important conversation because there are conceivably many different types of reuse that could be done that wouldn't require a discharge permit to groundwater or to surface water. And you've touched on some of those.
And my feeling is the legislature clearly gave the responsibility to this commission, the Environment Department, to oversee all those uses of produced water outside of the oil and gas industry. So we need to do that. You know, I can go on all night about House Bill 546 and how it was created, but one of the important things in there is that what was done was an attempt to parallel the processes before the Oil Conservation Commission with the processes before this commission. My processes, I mean the jurisdictional processes. Yep. You know, and so you already have under the Oil Conservation Commission all sorts of rules about storage, treatment, transportation of produced water, and so I think that's what the legislature might have been expecting for this commission and the Environment Department. Now, I'm not saying we have to mimic the regs of the Oil Conservation Commission, because that's dealing with a rather discrete process within the industry. There are going to be so many different variations about how produced water might be used outside of the oil patch that a lot of it, I think, will get handled more in the permit details than it would be necessarily in a regulation. But I still think those things need to be covered in a permitting process.
And are you proposing that they be covered in this particular rule?
Mr. Chairman, what I'm proposing is that we eliminate the NOI process for industrial projects, and that if the Environment Department wants a permitting process for industrial projects, closed loop projects, they can show up next week with a petition.
And I would just add, Commissioner Brankard, from the other side, I think that any applicant considering an industrial project would want the certainty of a permit rather than, as we've heard, an NOI, which can be revoked at any time. And so for the reasons that you mentioned, that I mentioned, I would second your motion to strike.
So have you made a motion?
Yes, I move to strike all the industrial project references.
I just
Four
wasn't
hundred
quite
B
sure.
and C.
Okay,
Can I ask a question, Chair Thompson?
yes, and let me just clarify. And Commissioner Zemlik has seconded that motion?
Yes.
Okay. I was writing things down and got behind a little bit. Commissioner Harms?
Um, for me, when I think of an industrial project, I'm thinking of road construction, maybe cementation. Is that what you're thinking? You know, that's closed loop where it's a controlled environment and we're not releasing anything into the environment. Is that what you're trying to separate out in this motion?
I have the, oh, he's got it.
Or is there another industrial project that I'm not aware of?
Doesn't define it.
Are you on the?
Mr. Chair, if I can answer that question, industrial project, I think is rather broadly defined to say that using reuse water in connection with industrial projects such as alternative energy, hydrogen production, cooling water, process boiler feeds, utility power plants, chemical plants, and metalworking facilities, where at minimum, public access is restricted or limited. Interesting.
Okay, so it's irrespective of the volume, is that right?
Oh, yes, it could be anything.
Okay,
And presumably a power plant's gonna be, it's gonna be a pretty sizable volume.
okay, that's all my questions, thank you.
Okay. Further discussion on Commissioner Brankard's proposal, his motion. We ready to vote? And again, Ms. Jones, let's do this by roll call.
Okay, to vote on Commissioner Brankard's motion. Commissioner Brankard, how do you vote?
Yes.
Commissioner Fry?
Yes.
Commissioner Harms?
Yes?
Commissioner Laney?
Yes.
Chair Thompson?
Yes.
Commissioner Bayless?
Yes.
Commissioner Vehil?
Yes.
Vice Chair Zemlik?
Yes.
Motion passes.
Good, thank you. Thank you. Okay. Now, are we ready to go through the markups suggested by the various parties? This would be, they've been summarized in attachment A provided by the hearing officer. Okay. So shall we start at the top? Commissioner Fry?
Sure, that's not what I was waiting for.
Okay, so, boy, there's a lot of suggestions. 44 pages of them. Okay, the first one, we're going from the top then. The first one is the issuing agency. It is, oh, I'm sorry, the first one is the title,
The title of the.
Part 8. Okay, and I don't know if everybody can see it. It is presently ground and surface water protection supplemental requirements for water reuse. And it has been proposed to strike out supplemental requirements for water reuse and change it to produced water. Okay, so the title would be ground and surface water protection dash produced water.
Mr. Chair, may I make a suggestion?
Please.
That if anyone who wants to go with any of these proposed changes, they make a motion. Otherwise, we just assume we're sticking with the Environment Department's proposal.
What's the commission feeling on that?
I like that idea.
I think that's a great suggestion. Okay.
Chair Thompson,
Yes, ma'am.
just because I feel like that's a big enough suggested change, I would like to bring to attention that this rule is not just, and you've brought this up before, it's not just about produced water. Ultimately, this rule will be about water reuse, and produced water is only one section of that.
Okay. So I am not seeing any willingness to, or interest in changing it. We'll leave it as is. So the title will continue to be ground and surface water protection dash supplemental requirements for water reuse. Okay. Now we go on to the 20.6.8.1, which is the issuing agency. It's the Water Quality Control Commission. 20.6.8.2 is the scope of the rule. It currently reads all persons subject to legislation implemented through the department pursuant to the Water Quality Act sections 74.6-1 et seq NMSA 1978, and specifically to persons intending to reuse wastewater and their operations. Any concerns with that one?
I like the changes proposed by Amigos Bravos and, well, several parties. So that is to add, this rule applies to all persons subject, and then removing that next clause to continue to the Water Quality Act sections, blah, blah, remove, et cetera, and then the rest stands.
Thoughts?
Mr. Chair.
Yes, Commissioner.
I don't think we need to go too much into this kind of detail because our council, Environment Department council, will have to work with the State Records Center to get it in the proper formatting. And they have a lot of little tricky little things about how to format statutes and whatever. But I know they hate when you say this rule. And in fact, I looked at some other regulations and they start out with 20.6.8 NMAC applies to, would be the proper way of doing it.
Okay. Commissioner?
So I was just making a quick glance at previous rules that the commission has passed to see the consistency. And I would agree that they don't like this rule. And some of this, the reference, while correct, is also not how the commission has done that in the past.
Okay. Further thoughts on this? My question on this one is, should the statutory authority also refer to the Produce Water Act?
It was the Produced Water Act that prompted this whole rulemaking.
We should accurately reflect the statutory authority.
Okay. So you guys want to vote on every one of these things? Would anybody have heartburn if we added the statutory authority would also include reference to the Produce Water Act?
Mr. Chair, it actually shows that on page 2, at the top of page 2, statutory authority, Water Quality Act, Produced Water Act. Oh.
Mr. Chair, I think the difference is that the scope is to entities that are regulated under Water Quality Act. The Produced Water Act, while it does apply, also applies to a whole lot of other people. So you wouldn't necessarily want to use the produced water in the scope, whereas you would want to use it in the statutory authority. That's the only way I can kind of figure out why it was done the way it was done.
Okay.
I would agree with that. We're explaining the scope, and you're correct that Produced Water Act has a larger scope than just the water quality. So I agree. And then it does state it in the statutory authority, which explains where the statute comes from. So I think there's clarity there as well.
Okay. Everybody agree? All right, let's move on. The duration, and we already have dealt with that this morning.
I'm sorry, Chair Thompson.
Yes, ma'am.
So a few days ago, I found the rules of rulemaking. And it does say that if the state's records administrator notifies the commission of having made minor non-substantive corrections in spelling, I got one of those suckers in my mouth and now I can't talk. Goes on, and then the commission administrator shall provide to the public notice of the correction in 30 days of receiving the state records administrator record of correction. So my question is, what would minor non-substantial corrections be? And NMOGA makes a recommended change to 20.6.8.2 that doesn't seem totally non-substantial to me. And so how important is it? What is an important enough one to go over? How are we going to get at that?
You're excused. I don't know.
I think since it's laid out here and they presented it, it's worth walking through.
Okay. So we should consider NMOGA.
Yeah, I think you should consider NMOGA, and it's not really contrary to either the multi-party suggestion or the NMED suggestion. It's like further clarification. Replacing the words "and their operations" with "unrelated to exploration, drilling, production, treatment, or refinement of oil and gas," which is, I guess, the description of what OCD handles.
Commissioner? Heavy sigh.
Yeah.
Personally, I would have no objection to including the underlined suggestion by NMOGA, which reads unrelated to exploration, drilling, production, treatment, or refinement of oil and gas. That language shows up in other parts of the proposed rule, I believe.
Mr. Chair, I don't see the need for that because if it's under the Water Quality Act, it's not going to be related to exploration, drilling of oil and gas, right? That's the Oil and Gas Act. And B, this part applies not just to produce water, but to reuse water. So I don't necessarily want to mix those issues. So I guess I just see it as unnecessary, that language.
I would agree with Commissioner Rankard that it isn't necessary. Nowhere in the scope are we implying that it is related to the exploration of drilling, et cetera. So we also don't need to clarify that it's unrelated because that's not our scope.
Thank you. So I'm hearing that we don't want to include the suggested language, the language suggested by NMOGA. Is that true?
I'm fine with that.
Okay,
Yes.
let's move on. Next is the statutory authority. I think there's some I would see these as editorial suggestions on how the Water Quality Act and Produced Water Act are cited. I'd say we leave that to the council and the legislative drafting service or whatever the says.
Council service.
Council service.
Yeah.
Okay, 20.6.8.4 is the duration. We've agreed that this shall expire December 31st, 2030. Okay,
Which page, can you, as you go, can you do page numbers?
I'm on page 2.
Page 2.
Page 2 of the attachment A provided by the hearing officer. Okay, the effective date. I don't know how these things work, how.
The State Records Center will let the Bureau know what the effective date can be.
Okay. Thank you. The stated objective. There have been a suggestion by CGFCM. I'm not quite sure what that group is.
That's the Center for, let's see, Biological Diversity, Wild Earth Guardians, and the Frontline Community Members, if I remember correctly.
Okay. Yeah, okay. So the stated, they offer language to the stated objective. And I'll read it for folks that don't have it. It's the objective of 20.6.8 NMSC is to, and here's the language that they're offering, to regulate the use of produce water subject to jurisdiction of the Water Quality Control Commission under NMSA 1978, section 70-13-3, section B. Thoughts on that?
So since this is intended for water reuse as a whole and not specifically just produced water, that wouldn't accurately reflect the objective of the rule. So I'm not in support of the edits that they've proposed.
I agree.
I do too. Okay, seeing heads nodding, we're going to keep the original language at 20.6.8.6. Now here we go with the fun things according to Commissioner Brancard, which is the definitions, 20.6.8.7 definitions. The first suggestion from Amigos Bravo Sierra Club is that capitalize the words part and terms. Again, I think this is something for the legislative council folks to determine. And then this other one is maybe something for us to address, and that is replacing the words will with shall. I know that there's legal issues associated with both words, and I'll look to the attorneys. Perhaps council has some suggestion as to whether we do change will to shall.
That really is dependent on the intent behind the original rule. I mean, it's fact specific.
So the particular question though is in 20.6.8.7 in this sentence. Following terms as used in this part shall have the following meanings. Terms defined in the Water Quality Act but not defined in this part will have the meaning given in this act. Should that will be changed to shall?
I think shall would be better.
Any of the commissioners have thoughts about that?
I mean, as from a non-legal person, that just means that the definitions that aren't in the Water Quality Act that are defined here are the definitions that we would go with as part of this rulemaking. What's the difference between will and shall? Is shall more forceful, more formal?
It's typically construed more forcefully.
Okay.
And in the end, statute controls, so it's sort of stating the obvious.
Okay. I agree with that.
I would support our council's recommendation of shall.
Okay. Is that clear? All right, let's keep going. Terms beginning with A. The first one is agricultural application.
So, Mr. Chair, I'm sorry to interrupt. Do you want to take up the more general question that's being posed by Amigos Bravos Sierra Club here as laid out on pages 3 and 4, which is, should any term be included in the definition? I believe they identified 23 of them or so. If it is not used in the rule or is only used in another definition, that's the larger question that's raised right here.
Everybody clear?
Mr. Chair, there's a Amigos Bravos Exhibit 12 that actually is a chart. And it tells you which ones are used in another definition and which ones are not used at all.
Yeah. Personally, I agree with their position that unused phrases, unused words should not have a definition. And I understand the environment, we discussed this in the Environment Department's presentation. This came up, and the idea was that these would be placeholders as the rule was developed to address other types of reuse. I think it was Amigos Bravos Sierra Club made the observation that it makes the rule longer than it needs to be, and it adds confusion. I'd also add that some of these phrases may change in subsequent years as the industry, the wastewater reuse industry, and I'm using that in its broadest context, develops new procedures and ways of reusing wastewater. So my inclination would be to eliminate the words that are not used.
Mr. Chair? Yeah, just for the purpose of discussion, bring up the Environment Department's, one of their arguments is that in their permits, they use these application terms, which are the sort of the biggest violators of this, of Amigos Bravos's concerns here. And so it's helpful for use of their permits to do that. Now, I may have brought this up during the hearing, but I thought the easiest way they could have solved all this was to simply put one sentence in the rule that said, each water reuse discharge permit shall identify an application. If they'd done that, then all of this would have been very relevant and easy to, for me to support, but they didn't. So that's just to throw out what their argument is. Why bother having these terms in there? And it's because they use them in a lot of their discharge permits. Water reuse discharge permits.
Yes.
So are they currently defined? I'm sorry for interrupting. Are they currently defined somewhere else? They're defined for the first time here, but they're currently used in permits?
That's a good question. You know,
I think I can answer that. They said that it is not defined somewhere else, which is why they want it here. And the ambiguity chews up resources.
Okay. Does removal now exclude us from adding them in the subsequent rulemakings? Okay. Well, with that, then, then I don't have a large objection to it. Typically, I tend to side with the department's standard processes. And if this is kind of a placeholder, somewhat of a checklist for them to make sure that they include it in the final rulemaking, that's where I'm inclined to go. But again, I don't have a large objection to it if we can add it later.
Chair Thompson?
Yes, ma'am.
I have to admit that during the hearings, I had a ho-hum response to this, that why do we care if they're in there or not? But it's so easy to add them back in. I don't have any problem with taking them out.
I just also wanted to add, Chair Thompson, since what we're deliberating, the rule that we're talking about here doesn't really directly address those specific uses. For example, a prohibition on irrigation use, then why include it?
I would agree with that. I think that it is, I know that the argument was that it added clarity and it made the rule more concise, but when the definition isn't actually used in the content of the rule, I think that actually creates confusion when the regulated industry is looking to see how is that going to affect me? And all they have is a definition. And this has been clearly set up so that it can be added to later. There's sections being held for that intention. So to me, it seems like it's unnecessary to have these unused definitions at this time because they're not used in the rule, they're not providing additional clarity, and they could be defined later.
So my question is, can we vote to remove them all right now, or do we have to go through every one and make a decision?
Yes.
Commission Council, the proposal from Amigos Bravo Sierra Club was it was a blanket objection to any terms not used in the rule or used only in other definitions. And as Commissioner Brankard pointed out, those 23 terms are clearly identified in their Exhibit 12. So seems to me a broader motion would not be inappropriate. But a broader motion, rather than going 23 times, that a broader motion acting on Amigos Bravo Sierra Club's suggestion is not inappropriate.
I agree.
Okay.
I have a question.
Yes.
So for those terms that are used in another definition, is there any reason to consider those separate from the ones that are not used at all in the rule? I'm just curious of the committee's sentiment on that. Does it clarify to have those defined if they're also then used in a definition? Or is that redundant again, and that we don't need to define things that aren't used in the content of the rule?
Mr. Chair, I guess I don't understand their objection to a definition that's used in another definition. But I think there's two categories here. There are some definitions that are used in definitions that are not used anywhere else. So, so it says here that, irrigation, land application is used in the definition of flood irrigation application. Right. So I would be fine with eliminating the ones that have not used another definition, or if they're used in a definition that is also not used in the rule.
Yeah, I agree. I'm sympathetic to the department's concern that there are terms they use in their discharge permits that are not in rules. But I think it would be more appropriate to, next time the Water Quality Act is before the legislature, put it in the act. And raise that a little bit because there was a couple terms that I suggested it be included in amendments to the Water Quality Act that came before this past legislative session, and they were not included. Mr. Armstrong.
I have a question on that note. Actually, the permit themselves, doesn't it include a definition section where it defines any of the terms, or is that not, I'm not intimately familiar with that. I apologize.
I don't know.
I don't either. I thought that was the case, but I could be very wrong.
I don't think we have the 95 reuse discharge permits in the record.
So single discharge permit. Okay, so
So just to throw a bone in here. So we have National Pollution Discharge Elimination System defined, and then you have NPDES permit defined, which is for the permit, and then they define an NPDES somewhere else. And the point is to remove the term, the definition, National Pollution Elimination System from the definitions because it's only used in the definition for NPDES permit. But their definition is very clear to me and helps me as a reader of this. So maybe some would be combined.
Is the definition, so I'm sorry, let me get on the same page as you. The NPDES is.
So NPDES permit is not on the list to be removed. So it must be in the rules somewhere. But National Pollution Elimination or National Pollutant Discharge Elimination System is only used in the definition of NPDES permit.
And you feel that the definition for the National Pollutant Discharge Elimination System is important to understand the definition of the
So they could
NPDES
be
permit,
combined,
right?
you know, but anyway, my point being, maybe we can't just throw them all out without going through.
Well, and that was my question, is the definitions that are used in a definition, are some of those, do we need to keep some of those? And of course, some of them are definitions used in a definition that are never used in the rule. So I think you bring up a good point that adds clarity to what the NPDES permit is, but that permit is used in the rule, you're right. So.
what's the pleasure of the commission?
Could we make a motion to remove all of the definitions that are not in the body of the rule and not used in another definition, and then look at the other ones one by one?
You know, we're struggling with this. Why don't we just deal with them as they come up? I think if there's anything quirky about it, well, we can deal with it at the time, rather than a blanket elimination of 23 definitions.
Then do we want to go through the table? Because looking at the attachment A, it doesn't specify that they have been asked to be removed.
Yes.
Yes, it does.
Yes, it does. So on the bottom of page 4, you see the definition of agricultural application as proposed in the petition. Then you see in italics NMED's support for including that definition because they have currently 16 permitted facilities reusing treated domestic wastewater for agricultural purposes. And then at the top of page 5, you see Amigos Bravos, Sierra Club, Center for Biological Diversity, Guardians, and Frontline Community Members, and NEE proposing to delete it.
I was looking at NTU, and that is on the list that it is not either in the body or the definition, but I don't see that it's stated so in the in section, in attachment A.
Okay, so if I'm, did I miss then, putting a statement in there?
Yeah, and that's why I thought maybe
Yeah.
it's
And, and again, I tried to address the larger
Yeah.
point at the beginning, but, you're right. It would have been good to have a statement under NTU.
It just so happened that's the one example I was looking at.
Okay.
Okay,
May I suggest we just keep it, all definitions in so that we don't go through those at this time? I think the department has a good point in putting these definitions in to clarify them either now or in a subsequent. I think it's adding confusion right now to actually say this is confusing writing. It's a couple pages of definitions. I don't really think it's worth our time to get hung up on it. There's no real harm in keeping it in other than maybe it's over laborious writing. I would rather be err on the side of complete writing than too laborious. So that's my suggestion.
I would prefer to delete them, but I don't feel,
Unnecessary because they're not used, and because that does create unclarity in what the regulation needs for those defined terms. Sorry.
what, anybody else?
I feel like the easiest thing is to begin by taking out those used in the body of the rule and those used in another definition. No, not.
Keeping
Sorry.
those.
Get rid of the ones that are not either in the body or in a definition.
I agree. I second.
Okay,
Is that a motion?
was that a motion?
So my motion is to remove any definitions that are in the body of the rule and are not used in another definition.
We need to formalize that for motion.
Well, it has been formalized as a motion. Any further discussion? Let's vote on it. All in favor of?
I'm sorry, excuse me, just, does anyone confirm this table is accurate?
What, I don't think that's important because we're going to go through them one by one.
Right, but this is the
Madam-
only indication.
Yeah, so, yes.
Did you-
The Amigos Bravos and Sierra Club set it out in a table and had Mr. DeSalen testify on each of those points. And if you go to their, the statement of reasons and closing argument on the pages that I indicate here in attachment A, you can see it.
So I'm just want to confirm, so Commissioner here has a table, so you look at number 3 on the table, whatever that word is, someone has confirmed that that word is defined and yet not used anywhere in the rule.
That's right. Mr.
So-
DeSalen gave that testimony.
Okay, so if the commission is comfortable that that information, because I think what I'm hearing from your proposal was that you will go through the definitions, and if it happens to be on the table, you will look at it, but you're not going to confirm whether it exists anywhere else, and you're just taking it, the fact that it's on the table.
We already, yes, the table was an accurate reflection of Mr. DeSalen's testimony.
Okay. Are you? And, okay.
You're saying this is accurate reflection of somebody's testimony, but has anyone confirmed that he was accurate?
Oh, I think the Bureau would have put on rebuttal testimony if Mr. DeSalen had said, oh, the word, produced is never used in the rule, right? They would have rebutted that. For them, it really was about wanting to define terms that are used in the discharge permits they were already issuing for reuse, as opposed to having something in the rule.
All right, are we ready to vote? There's a motion to remove definitions that aren't used in the rule or that are not referenced in other definitions. That's an accurate, everybody in favor of that motion, say aye.
Aye.
Opposed? Okay, so that carries.
Okay, and would it be helpful then, I mean, it'd be helpful to me if you would just name those definitions.
Okay. So commercial application. Got it right here. Discharge plan. Discharge sites. Flood irrigation application. Food crop application. Industrial application. Injection. NTU. Recycled produced water. Restoration application. And ecological application. Oh. There's possibility that some of the ones used in another definition are maybe some of those that we're getting rid of. Yes. I don't know which ones.
Okay. Are we ready to keep going?
Could we take a short break?
Yeah, good suggestion. Let's take a break until it's 10 till 3. Let's take a break till 5 after 3. 15-minute break. Since you had a gallon of.
Agricultural applications.
That is used in livestock application and reuse.
I'm looking at item A, agricultural application. This is one that Amigos Bravos Sierra Club, well, it's been proposed that we delete this definition, so we're going to move on, right? Next one is application.
I'm sorry,
Yeah.
Chair Thompson, I think Commissioner Fry clarified that she was not proposing that this be deleted. It was one of the ones y'all were going to take up. And Commissioner Fry mentioned that it's used in the definition of livestock application.
It's used in livestock, the livestock application and reuse. Two different definitions.
But livestock application has been proposed as another definition to be deleted.
Only because it's, well, it's not in the body of the rule. It is in, oh yeah. They're both in each other's application.
Yeah.
So agriculture application is used in reuse, which is not being proposed to be deleted, but livestock application is being proposed to be deleted. So, yeah, I think we could, no.
I'm searching in many ways.
I don't find a definition for reuse.
It's water.
There's a definition for reuse water, but not reuse.
So are you saying we should keep agricultural application?
No,
Anybody arguing in favor of keeping looking to the representative of the Department of Ag?
There we go.
Just
It's not used in the content of the rule, so I don't think it's necessary to keep this definition at this point in time. It can be brought back when there is water reuse that would suggest agriculture application.
and since I don't find a definition for reuse, and the only other place that livestock application or agriculture application are used are in their own definitions, I would suggest we remove both.
Okay, everybody agree? So we're removing both agriculture and reuse,
Agriculture
livestock?
application and livestock application.
Yeah, just sort of reference the stream standards, 20.6.4 refers to livestock watering, not livestock application. But, okay, so anybody have any heartburn about, let's go on. Application. Again, CGFCM and new energy economy, NEE, proposed to delete this definition. Anybody have heartburn with that? Okay. Terms beginning with B, bench scale project. Now, this is one that I would propose that we delete this. I don't think bench scale projects should be subject to this type of regulation.
I think we need record, I think NMED needs record that they're occurring in the NOI process.
You know, in decades doing bench scale studies of one kind or another, I've never known of anybody that has been subject to any type of state regulation on bench scale.
Mr. Chairman, the phrase bench scale is also used in the pilot project definition. So I guess maybe it'd be helpful for you to lead us through sort of all three definitions here. Pilot project, demonstration project, and bench scale. And what do you think we should keep and not keep and maybe modify?
Okay, well, bench scale is done in a laboratory. A controlled environment, the water is discharged usually to a sewer, and it meets NVDES requirements. Usually it's pre-treatment requirements, but it's done in a laboratory in a very controlled environment in very small volumes. Often we're dealing with, less than a quart, a couple hundred milliliters sometimes. Sometimes it's bigger, but I've never known of a bench scale pilot that was subject to a bench scale project of any kind that was subject to state regulations. The one exception being if you're working with radionuclides, then the laboratory has to be certified for working with those materials. And that, at least at UNM, it's overseen by, I believe, the Radiation Protection Division. So that's bench scale. They're done in a laboratory. Sure. Pilot scale typically is done at a much bigger scale. It may be done in the field. It may be done in the laboratory, but it's a much bigger scale. And I'm thinking a pilot scale is being something where you are doing, you've designed a facility that is sufficiently complete that you can scale up to prototype design and you can do economic analysis, financial analysis. And then demonstration is sort of, could be anything. I mean, I've seen demonstration projects, the waste isolation pilot plant is a pretty good example of something that is much bigger than what is normally considered to be a pilot project. Demonstration project could be a full-scale prototype. It's a one-of-a-kind to demonstrate the technology. And so I'm really uncomfortable with demonstration projects. I prefer to define pilot projects and put a size, a maximum flow rate on it. Whacker.
Okay, so if we get rid of bench scale, that means we can get rid of demonstration project because demonstrations project is just pilot plus bench scale. We're left with pilot project. Okay, I would ask you to look at the definition of pilot project where the phrase bench scale is in there and see if you want to modify that in any way because we no longer have bench scale.
My markup strikes bench scale from the definition of pilot project.
So would it read representative engineering scale model or prototype system that is tested in a non-laboratory environment?
Yeah, or actually, I misspoke. I did not strike is beyond the bench scale. I did not strike that. I apologize. We can leave it in there, but I don't think we need to. If just tested in a non-laboratory environment would be satisfactory. And it would eliminate the need to have bench scales defined.
I have a question.
Yes, ma'am.
Thought. So bench scale is used as we've all discovered in demonstration project, and demonstration project is used in the NOI. So would bench scale, if we remove the definition and get rid of demonstration project, then no longer be required to submit an NOI? If it's no longer being defined, that's what it would suggest, in my opinion. And is that our intention here?
Because at that point, they're not reporting to the department potential research results, right?
Which leads to my question. So you have, my understanding is that NMED wants to be able to track all research being done on produced water. Are you willing to place a value judgment on bench scale to say that it's not worthwhile to track? Because if you're not saying that, then the definition should stay in here and bench still needs to stay in the rule. And it's not the intention so much as to regulate bench scale as it is to be able to track it and collect data from it.
The Environment Department has asked for the Produce Water Research Consortium to report their results. And so that's where the information from the bench scale project would be provided to the Environment Department. They don't need to know about it at the beginning. They don't need to approve the methods, the scope of work. They need to see the final results because the reports on the final results will have all that other information.
But isn't the notice of intent the mechanism that lets NMED know that this research is occurring and then that those results should at some point in time be expected? And then notice of intent doesn't limit them from doing the bench scale studies. It just is to let them know that they are occurring. Is that incorrectly understood?
No, I think that's if we keep that in here, that's likely the result. And I think that's just a waste of everybody's time.
Well, on the one hand, you have the bench scale projects and you want the data, but you don't want those students to have to wait 18 months to get a letter back from NMED saying you can go on with your research, right? But you don't want larger scale pilot projects to just have this, you just notify the department and go ahead with what you're doing. So I think is the balance the consortium for the data? Is the NOI is that what is currently happening with any produced water research? I think it's probably inconsistent at best if you're talking about labs and students. I mean, my recommendation is my recommendation would be to not require bench scale projects to go through the NOI process, which seems more burdensome to me than just reporting that information to the consortium.
Absolutely. I agree on the burden for sure, because I mean, usually these projects would be done in a timely fashion for the student because they're trying to either finish a bachelor's, a master's, a PhD or something. But is the amount of water used in these bench scale inconsequential to the regulation? Because if you don't have to go through the NOI or the permitting process, it would suggest that. And I don't know, I mean, I'm not familiar with the size of these types of projects. I am not a researcher, so you guys would have a better idea on that than I do.
So if we're talking about removing bench scale, then who are doing the pilot projects? And in that case, why are we doing NOI if, I mean, is it industry doing the pilot projects? Is it actually engineering departments doing the pilot projects?
I think it could be anybody doing pilot projects, industry, consultants, universities. And I think we need the NOI because the potential risk of an improperly done or improperly designed study could be significant. But for bench scale,
So in that case, if we're, I mean, do we need to know why NMED chose to include bench scale in this proposal? Because if that's the case, then.
you know, one of the things we heard testimony that they wanted peer-reviewed research, but there's nothing in here that requires peer-reviewed research. It's sort of interesting. I mean, yes, peer-reviewed research is sort of the gold standard, but it's not necessary. Not in every case, not to generate the type of information we want. That's sort of an aside. Again, I'm not aware of any type of state regulation that governs what goes on inside a laboratory. Commissioner.
Let me throw this out as a possibility that we focus the NOI provisions on pilot projects, but then we get all the way to the end, 400C2. Which is the research results, and we apply that to both pilot projects and bench scale projects.
That would ensure that the research goes to the department, which is the kind of the goal of this, is to make sure that they have research to understand produced water.
And then I would say then we add a sentence to say that bench scale projects are not required to have an NOI. And we keep the definition.
That's the idea of me requiring an unfunded master's student to submit their project to the environment department is concerning. Some of the work is really good, and some of the work you kind of hold your nose and turn away and then vote in favor of passing. Requiring me to submit that bothers me.
But we are trying to gather data and understand what's happening with all of the studies that are being done. And we are trying to get sound scientific data to support our permits under the Water Quality Act. So I think the fact that the Produced Water Consortium hasn't produced a white paper, and basically you're saying, well, they will be producing data to NMED under some some requirement. They're going to be producing it, but they're not producing the white papers that we need to rely on to create the science. And so that's why I think this Part C is all encompassing for demonstration projects, both bench scale and pilot scale. I would recommend we keep it as is, but still open to hearing thoughts and carrying on the discussion.
Okay. Were you reaching for your microphone?
So I guess just one last thought on this whole bench scale. It's not limited to universities alone, correct? So anybody could carry out these types of studies. I tend to agree with you wanting that data, and I also understand that sometimes that data is trash. Just depends on who's done it, how they've set it all up. But it's kind of a difficult rub. I tend to lean towards including the definition just so that it's clear.
I go back to what is the lab process? What are they doing with their waste? You know, student without some kind of instruction might be just dumping it down the sink. So maybe this is needed to help make sure that, you know, labs are taking care of the waste properly, for example.
All the universities that I know of in the state are subject to pretreatment criteria under the NPDES program. And so that governs the disposal of laboratory waste. So, and then someone had a question, what are the volumes? We're talking about a few gallons. We just finished a study using produced water. It was for something else. It was corrosion. I think we had a total volume over 3 years of 1.5 gallons or something like that. This was with Jose.
Hmm.
Yeah, I'm not going to fall on my sword on this, but I think this is something unprecedented in my experience. Putting bench scale laboratories subject to reporting, even though it doesn't require approval, subject to a reporting in a state regulation is unprecedented. So we ready to act on it? I don't want to get bogged down too much.
I want to pose one more question. If you keep bench scale in here, let's just say you're starting as master's student, bench scale is in here, you don't file your notice of intent, you get some really promising results, you want to move to the pilot scale, but you come back to this because bench scale is included and you haven't done the things that are in the notice of intent. If I were a regulator, I would say you don't maybe get to advance to the next step. And I would think that's unnecessarily stringent for what occurs in the lab. And I think requiring reporting of all of this stuff isn't going to do the science for the department or for anybody else. It's still going to require a lot of additional analysis. And I would agree that based on the material we're talking about, it seems like the department's gonna get flooded with a bunch of things that they're gonna have to try and analyze and make a value judgment for, when there's plenty of research that's happening, that's getting published and peer reviewed and things like that already. And I think the intent is to move beyond the bench scale, so.
That's a very good point. And then to that end, would they be in violation if they had carried out their bench scale study and not have issued a notice of intent?
Well, I think when you move to the bigger step of the pilot study, saying, hey, we did this great thing in the lab, now we want to go big, you started a new notice of intent for the bigger project. So it would be seen as two different projects. That's my understanding of it as well. Just to get some clarification, are we talking about, oh, you know what, let me ask a different question first. When we say small, are we talking about gallons or pipettes in the laboratory? Because small is a relative term, or are we defining it on an actual amount? I think it would be best to leave the discretion up to the department. But I just wanted to clarify that since that came up earlier. What are we, the amounts that we're talking about?
Yeah, I mean, from a practical perspective, in the laboratory, you can't deal with large volumes. You know, anything more than, you know, a few gallons, maybe 10 gallons over the course of 6 months or something like that. One other thing I didn't point out, if I think if you require everything to be submitted to the Environment Department, there is a very realistic possibility that it will be misinterpreted. So I will have a student that does a very poor piece of work, or it's incomplete or something like that. It gets submitted. Now it's on the Environment Department's website, and somebody who is objecting to something or other can go and they can find it, because this has happened to me. They can go and they can find something and they say, oh my goodness, we can't do this because. And I can give you 2 or 3 examples of that happening, but I think requiring this is problematic.
And to add to that, I don't think students are ready for that kind of scrutiny until they go through the publication process as well. It's like, that's what that is meant to demonstrate, is the quality of your research. So I agree.
Okay, we need to put this one to bed. Do we include it or not?
Well, what I'm wondering is, do we want to include something that says that the NOI does not, that process does not apply to these? I think you had suggested that. I don't know, this,
Well, if we
this
strike-
might be, the rest of this might be weak, but you know, the department requests data from peer reviewed papers for bench scale projects.
The way I envision this working is that when someone submits an NOI for a pilot scale project, they're required to provide supplemental information that justifies the design and the scope of work and the procedures that are used in that pilot project. And so they'll pull out reports, preferably from refereed literature, but maybe not always. They'll pull out reports, and that is what the department will see. The information that is used to justify approval of a bigger scale project. And it might not even have been conducted in New Mexico. It might have been conducted by someone in a different state, a different university. We're getting bogged down.
So going back to my question, which I think puts this to bed, do we want to not include this throughout this? And then maybe just have a sentence at the end of NOI for, I don't know, clarity. About bench skills,
Include it later, then we need to have it defined.
Correct.
right? See, that's my question. We put something, short sentence at the end of NOI, and then we keep the definition.
I would say my preference would be to strike bench scale, the definition, and strike it everywhere in the proposal.
Sounds like a motion.
I move that we strike bench scale from the definitions and all other references in the proposed rule.
Second.
Discussion.
Bill's over here.
How about if we delete demonstration project?
Do that too.
And wherever
At a time.
demonstration and project appears, insert pilot project. Okay? But I don't know that I would eliminate bench scale because I think we haven't quite decided whether we want to allow these people to submit anything or, plus bench scale is used in the definition of pilot project.
And again, I would strike it. I don't think a bench scale project done in New Mexico needs to be the basis of approval of a pilot project.
Right. But right now, what we're approving are demonstration projects, which are pilot projects plus bench scale.
Right now, we're talking.
If we
about
eliminate demonstration projects and replace it with pilot projects, we've eliminated bench scale projects from having to do the NOI process.
I'm completely comfortable with that. In fact, I was going to get there, but we haven't got to B yet.
He's right now got a motion on for bench scale project to remove it completely.
I know, that's why I'm discussing it.
Are we ready
Explaining
to
why I
vote?
might vote no.
So is the implication of this rule would not apply to any bench scale projects at any point? Okay, so that students can research this at will without having to go through NMED regs. Okay, and to be clear, I think if we don't require it in the NOI, I don't think any reporting would happen to, there would be no mechanism to report it to NMED. So the only time we would receive those results would be through a white paper, publishing a white paper if those students get to that point. Is
Yes.
that the idea? Okay.
Or and NMED could identify the study and request the results as they did for many of the references that they cited. Okay, but it doesn't, we're not requiring the researcher to submit an NOI.
And just for an additional clarification, it is not just students doing bench skill projects. It's professors, professionals in labs.
Consultants, agencies, yes. Are we ready to vote? God, it's gonna be a long day. All in favor of eliminating, my motion, again, let me restate it, is to remove the definition of bench scale and strike bench scale from any reference in the proposed rule. Is that clear? All in favor, say aye.
Aye.
Opposed?
No.
One no? Do we want a roll call vote? Do you want a roll call vote?
You want to elaborate?
I don't think anybody abstained, so I think we know what it is.
Okay, so it's passed. One no vote. Next is commercial application.
It's already been
That's
deleted.
removed.
It's already been deleted. Thank you. We're on D, demonstration project.
And I'm sorry, I forgot to mention a repeated request that when you speak, before you speak, to just say this is, so this is Felicia. Thank you.
This is Bruce. So demonstration project. Again, I've referred to it several times. I'm troubled by that because demonstration project could be very small scale or very large scale. I would prefer that we replace demonstration project everywhere in the proposed rule with pilot project. And further that we put, when we get to P, we put some maximum capacity on pilot projects.
If that's a motion, I second.
That's a motion.
Second. Mr. Brancard.
Discussion. Ready to vote? Okay, all in favor of eliminating demonstration project in the definitions and throughout the proposed rule, say aye.
Aye.
Opposed? Okay, let's go on.
Mr. Chair, if I understood your original motion, it was eliminate demonstration project and replace it with pilot project.
Yes,
Thank you.
yes. Okay, well, yes. Thank you. Thank you for the clarification. Yes, okay. Now we go on, department. That's, nobody has any concerns about that. That does refer to the NMED. Direct potable application. This is direct potable reuse of wastewater, domestic wastewater. It's not used in the rule. Three of the groups proposed to delete it. And I support that. I don't think we need it in this rule yet. When the department comes back to us with wastewater reuse regs, that would be the appropriate time to include the definition.
Do we need no, do we have to vote on that or?
We don't have, and not unless somebody wants to. So the question was, do we need to vote on it? Is there anybody that wants to keep a definition of direct, I think it was direct potable application? Hearing none, let's move on.
Mr. Chair, okay.
Commissioner Brank,
Is the goal to replace direct and indirect potable applications with potable applications?
that's not my intent.
So the definition is used in other definitions. I'm sorry, Katie Laney, the definition is used in other definitions, which currently we've kept. Or at least, did we keep application?
Yes.
Yes, so direct potable is in the content of that definition, but that bears the question, is it necessary?
Direct.
I thought we deleted application.
Yeah.
Can I jump in here?
Yes, ma'am.
So if you go to potable application or potable, you have a definition of potable, which is apparently in the document. They propose the definition to replace the definitions of direct potable application and indirect potable application for the reasons stated above, which I'm not finding that. But this is from Amigos Bravos and Sierra Club. And I thought they had a clear reasoning why. I just can't find it.
Sorry, I looked it up. It is not, direct potable application is not used elsewhere. You are correct. Direct potable standalone is, but not direct potable application.
I mean, section 201 is all about direct potable applications and indirect potable applications.
So to answer your question, Commissioner Fry, because Amigos Bravos and the rest of them had already explained on page 7 why they would replace the words direct potable application, indirect potable application was simply potable application. I didn't repeat it on page 15. That's the reason stated above.
Okay, shall I read that quickly? The definitions of direct potable application and indirect potable application should be deleted and replaced with the definition for potable application because there is no meaningful or useful distinction between direct and indirect potable applications in the context in which they are used, i.e. in feasibility studies for domestic wastewater in 20.6.8.201 NMAC.
I think as a former water resource planner, there is a distinction between direct and indirect potable reuse. So for me, I would prefer to keep it as is.
They're just saying for this application that it's not necessary to distinguish.
Yes, but I think it's important to just be consistent across our department and the industry standards, that the terminology not be changed arbitrarily. Just because you can combine them here in this context doesn't mean we should change it just for this context. I think keeping standards straight across the industry is important.
This is Bruce Thompson. I propose, the industry uses direct potable reuse, not direct potable application. I've not seen that. I would prefer that we use direct potable reuse, indirect potable reuse, and that section 201 refer to direct and indirect potable reuse. I mean, that is industry language. And this is a water reuse rule.
I'll accept that.
Thoughts? I'm seeing heads nod, so
My thought is it's confusing because in the definition of application, which this all ties back to, it refers to effluent criteria, which we don't have.
Yeah.
We don't, yeah, there's the prohibition part, so we don't have them yet, but are we removing application? You putting in reuse? I'm a little bit lost.
well, the definition of application means a final disposition of a treated wastewater for reuse. So I don't think it introduces any problems. Thoughts?
I agree with you. I don't think sorry, Miori Harms. I agree with you, Chair Thompson. I don't think it poses any problems. And I stand by my suggestion to keep the definition as is and not combine. indirect and indirect, or direct and indirect potable application.
Okay. What's the thought? Everybody agree that we'll change it to direct potable reuse, both in the definitions and elsewhere, which I think is only section 201. Well, yeah, it would be throughout section 201.
Is the word reuse more broad than application?
It's in the title of the rule.
Yeah, but is it like they're specifically talking about delivery of purified water to drinking water plant, blah, blah, blah. Is reuse broader than that definition?
I can't. I can't think of a scenario where it's not broader.
Where it's
Again,
not broader or where it's not different?
where reuse is not more appropriate than application.
So yes, you're saying you can't think of a
Scenario.
situation where you couldn't just insert reuse instead of application.
Yes.
Yeah.
That's true. And again, it's the industry standard. So the regulations in California are regulations for direct and indirect potable reuse. Okay. You ready to move along? Everybody agree? We'll change application to reuse. Okay. Discharge permit. An alternative suggestion has been offered by CG, FCM, and MEE.
Mr. Chair, this is Felicia Orth. As proposed by the Center, the Guardians, and the Frontline Community Members in NEE, they're proposing a definition. Discharge permit means a discharge plan, but you've already agreed to delete the words discharge plan.
Yes. Comfortable with that.
Mr. Chairman, may I go back for a second? I kind of got lost there on the potables. Was the only change application to reuse,
Yes. Or discharge.
but we kept direct potable, indirect potable? Okay.
Correct.
Because if you look at the definitions, there's a really important shift there. Reuse water is any kind of wastewater, including produced water. Potable water has to come from domestic waste.
The way it's presently defined.
Okay, so that's why, we have to be careful with messing with those terms.
Yes. I think you're correct. Okay, so we're going to keep discharge permits as defined in 20.6.2 NMAC.
I'm sorry, Chair Thompson. In follow-up to what he's asking, there was a request for adding some language to direct potable application / reuse, that it means the application of reclaimed wastewater for drinking water purposes through something or other. I'm not clear who made that suggestion, but maybe that kind of answers to
This
what.
Commissioner, I believe that's the Environment Department's.
That's correct, Commissioner Brankard.
Yes.
So we want to accept that addition from them.
I see heads nodding in agreement. Yes.
Okay.
Okay. Discharge plan,
Discharge site has already also been deleted.
discharge site has been remove. Disposal is defined in 20.6.2 NMAC. Amigos Bravo Sierra Club proposes that we delete that. Disposal site. Oh, I'm sorry, discharge site I'm looking at.
That's been deleted.
That has been deleted, okay. Disposal is defined, domestic wastewater. Amigos Bravo Sierra Club proposes a modification to remove the phrase, but not limited to. Care. What's the pleasure of the commission?
I'd propose leaving it as it is.
I would agree with that. It's kind of the catch-all. And is more protective. It's on the more conservative side to keep it in.
That's defined in the Water Quality Act. Okay. Let's move on. Terms beginning with the letter E. First is environmental buffer.
So it's environmental buffer is one that is not in the text, the body of the rule, but it is in the definition of direct potable application.
Environmental buffer becomes important when we deal with reuse of treated municipal wastewater. Okay. What's the pleasure of the commission? You want to keep it? Again, it has been suggested that we delete it because it's not in the rule.
Based on the importance that you guys are placing on the definition for direct potable water, I would suggest to keep it.
I agree.
Okay. Seeing heads nod in agreement. Let's move on. F is terms beginning with F. And it has been proposed to delete all terms beginning with F, which were feasibility study and flow back water and formation water.
Flood irrigation.
And flood irrigation, yes.
Flood irrigation application and food crop application have already been deleted.
Yes. So let's go through these one at a time. Feasibility study. Do we want to keep that in? I think it's used elsewhere, isn't it? In fact, I know it is with the NOIs. Yeah, so I think we want to keep feasibility study. Agreed?
Yes.
Okay. Flood irrigation,
Sorry.
Flow back water is actually next, this is Commissioner Fry, and that one was not used in the body, but it is used in the definition for produced water. And it seems important to me to keep that.
Mr. Chair,
yes.
it's Commissioner Brackett. I'm going to get on my high horse here. there are a couple of terms in the definitions that are terms that are defined in statutes. Okay? Not only does the State Rules Act say you're not supposed to repeat definitions and rules that are in statutes, but I get really nervous when we take a definition that's in a statute and put it in a rule and change the definition. Okay? I mean, these are not necessarily really substantive changes, but they are sort of adding things to what is produced water is the example here, where produced water is defined in 3 separate statutes in the same way. And we have decided, the proposal is to add a couple of sentences to that definition. And I just get nervous about doing that. Now, others may think it's important to have things like formation water and flowback water because that's something that people ought to know. I guess because I've dealt with produced water for years, I don't care. I know exactly what it is. But that's my concern is that these 2 terms, flowback water and formation water, have been added to the definition of produced water beyond what the definition is in the statute. I think the statutory definition is short and extremely broad. And I guess I wouldn't mess with it.
Let me read the statutory definition. Produced water means a fluid that is an incidental byproduct from drilling for or the production of oil and gas. And I agree, it's very broad. And from a practical perspective, there is no way to separate flowback from formation water. So I think the distinction is not important in the context of a reuse rule. Counselor.
This is counsel for the commission. You're exactly right. And this is in the statute. Any attempts to revise the statutory definition are ineffective. So you can have it in the rulemaking and it's just when you look at them 2 together, the statute will override. So attempts to alter or change the statutory definition and rules is not a good idea.
So Commissioner Brankard, you're suggesting we eliminate the definition of flowback water?
Well, I suggest we amend the definition of produced water so that it simply follows what's in the statute. And once we do that, we no longer need flowback water or formation water.
Makes a lot of sense to me. I'm seeing heads nod.
Yes.
Yeah.
Okay, so I'm gonna use the prerogative of the age and jump ahead to the definition of produced water, which is on page 16. And I suggest that we replace the definition of produced water on page 16 with that's in the Produced Water Act. They're almost the same, but the definition in the rule includes formation water, flowback water, chemicals added, and so forth. I think we ought to just keep it simple, and I completely agree.
So with that, we could also
So let's
delete flowback water and
Flowback,
formation water.
Yeah. Does everybody agree that we'll stick with the simple definition, the simple but broad definition of produced water? That's in the statute? Okay. Then going back to F. So we've we've eliminated flowback, we've eliminated food crop application, we've eliminated formation water. And we go to G, which is groundwater, that's defined in 20.6.2. Now we go to H, which is hydraulic fracturing.
Is that not already defined in the statute?
It's not defined in the Produced Water Act. So just, as a side, the Produced Water Act has 3 definitions: operator, produced water, recycled water, and treated water. It's very simple.
It looks like it's only used within the context of the definitions that we've already deleted.
It's used in flowback, which we just needed, or it was used in flowback. Instead.
Bang on it. No. Okay.
I agree. I think it's used in all of the definitions we deleted.
Okay, so we're proposing to delete hydraulic fracturing.
Yes.
Okay. Terms beginning with the letter I. And the first one is indirect potable application. And again, I would prefer to indirect potable reuse because that's the industry standard. And I don't see anybody that checks to that. Application.
That's been deleted.
Industrial project.
Well, my earlier motion was to eliminate industrial project from 400. So I don't know that it's there anymore, anywhere.
To remove industrial.
Industrial project.
Sorry, that was specifically in section C, is that correct? Let me,
It's all through 400 B and C.
okay, B and C, thank you. Good to go.
Injection.
Mr. Chair, Commissioner Brancard, even though the chart says it is not used elsewhere, I found that it actually was used in 400B8 about the whole section on disposal. But I don't know how important it is. I mean, injection's injection.
Yeah, it's just citing their regulation.
Irrigation application.
So that one was deleted. Injection was deleted, correct? Chair Thompson, you were deleting injection?
I mean, it's defined in
Okay,
groundwater regs.
got it. Thank you.
Should we delete it?
Our mics seem to have stopped working.
Oh.
Which one is the next?
No, mine works.
Oh, this one, let me have the one that's not working, maybe it needs to be charged. Oh.
Mr. Chair, I think that's a sign we need to hurry up.
So we're going to keep injection. All right. Irrigation application we've gotten rid of. The next one is land application.
That one is not used in the body of the rule. It is in the definition of flood irrigation application, which we have removed. So I would suggest we remove land application.
You suggested the removal of land application?
Yes, because it's only used in the, oh my goodness, it's time to go home. Definition of flood irrigation application, which we removed.
Yes, I agree.
Okay. Same thing with livestock application.
Yes.
You've already deleted
We've
that.
deleted that. And again, excuse me, remind the environment department staff, if you come back with this one, use livestock watering, I believe it is. Thank you. Next is National Pollutant Discharge Elimination System.
So that was suggested to be removed, but I'm wondering how that would work to roll that into the NPDES permit definition.
Yeah.
Let's say that for the record.
Should we eliminate National Pollutant Discharge Elimination System? Or roll it into the NPDES permit? I'm kind of inclined to keep it because people may, it's sort of hard to imagine, but people may not know what NPDES stands for. of pilot plant and the language, the projects shall have a daily produce water capacity equal to or less than 2,000 barrels per day. Agreed? Good. Potable, have we deleted that one? I'm looking,
Nope.
okay, potable. I had suggested language for potable, and it was potable water means water that meets state drinking water standards at 20.7.10 NMAC.
That was proposed by Amigos Bravos, Sierra
was it?
Club.
Great minds think alike. Thank you. Are we comfortable with that?
Yes.
Okay, let's move on. Pre-treatment. It's been proposed to delete this.
So it is in the definition of national pollutant elimination system.
We want to keep it?
I would keep it.
It's been suggested that we keep it. I'm looking, I'm seeing heads nod in agreement. Okay. We'll keep it. Produce water, and we've agreed with this one, we're going to use the definition in the Produce Water Act. All right? Cadence sat through classes. And when I see the students are kind of, their eyes are glazing over and they're falling asleep, I say, nod your head. Some of them.
This is the longest class I've.
But it's the most interesting.
Like 3 weeks.
Yes.
How long is the class?
Okay. Terms beginning with R, is that where we are?
Yes.
Terms beginning with R. Amigos Bravo Sierra Club proposes definitions for reclaimed water, recycled produce water.
Well, so reclaimed wastewater, there's, yeah, I guess nothing. Recycled produced water, that we had voted to remove because it's in the body of the rule and it's not, I mean, it's not in the body of the rule and it's not in another definition. And same thing with restoration application or ecological application. So reclaimed wastewater is the next and then reused water after that.
Okay, reclaimed wastewater.
Is that included in direct and indirect potable reuse? Probably.
What was the question?
Reclaim the wastewater? Yeah.
Mr. Chairman, this is sort of the essential link that shows that what we're going to use for these feasibility studies has to be domestic waste. You need this definition. It's where the domestic wastewater pops up and then appears in the direct and indirect potable.
Okay. So we want to keep it?
I just have a quick question. So are you saying that's in 20.6.8.201? I'm just not seeing.
No, it's in 26.8.201 is direct and indirect potable. This is part of the definition of direct and indirect potable, but it's the only place that mentions domestic waste stream.
Yeah, I got that, but I'm just saying, is it in the body of the,
No.
or it's in the
It's in the definition.
Okay, thank you.
Okay, we're going to keep reclaimed wastewater. We are going to eliminate recycled produced water. Yes? Nod your head. We are going to eliminate restoration application or ecological application.
Yes.
Okay, and then we've got reuse water. I had a minor editorial suggestion. Let me. No, I'm comfortable with the definition as is. No, I take it back. I do have an editorial suggestion for reuse water. I'm looking at the language proposed by the Environment Department. The very last two lines, there's a parenthetical comment. It says, e.g. domestic reuse is wastewater originating from domestic sources following appropriate treatment that may be used for various applications such as irrigation. I propose that we call domestic reuse is reuse of wastewater. Because domestic reuse isn't wastewater, it's reuse of wastewater.
Reuse of reclaimed wastewater, which was defined previously.
Chair, this is Commissioner Branker. Again, we have these various sentences in definitions that are trying to create sort of standards and requirements instead of just defining the word. And so I don't even know if you need that last sentence.
The parenthetical comment?
Yeah.
Yeah, Amigos Bravos Sierra Clubber suggesting to remove the parentheses.
I'd be happy with that. I'd be happy with that. I think, yes. It reduces its length and potential complication. Okay, so we'll go with the definition as on page 18 in Appendix A, but we'll remove the parenthetical comment.
Like at the top of page 19.
Yes.
Like at the top of page 19. Okay. I'm seeing heads nod in agreement. Okay. Definitions beginning with S, state means state of New Mexico. Surface water means surface waters of the state is defined in 20.6.4.
No one had any other proposal.
Thank you. Terms beginning with the letter T. Proposal to delete definition of transference and treated wastewater as being unnecessary.
So transference is not in the body of the rule. Transference is in the definition of treatment. In the definition of treatment, it was proposed to remove the word transference and instead include the words transfer, storage, and disposal.
Yes, that's what I was looking for.
So are we going to do that and we can get rid of transference as a definition?
To me, the department's note is pretty compelling to keep it in as is, because to eliminate confusion And I thought I recalled the term transference in the Produced Water Act, but maybe I'm misremembering.
I think it's transfer, not transference, I believe. Yes. In the Produced Water Act, they use the phrase, take possession of the produced water to use, handle, dispose of, transfer, sell, convey, and so forth. So transfer is in the Produced Water Act. I don't think that needs definition.
No, the definition of transference too is not correct.
It's not correct, so.
No, if you look up what transference means, it's not the same as transfer.
I thought you were saying that it's been defined as incorrect.
Well, it's transfer and transference are two different things. And I think to redefine transference as same thing as transfer would be confusing.
Okay, so I think the sentiment is to delete transference from the definitions.
And then, yes, and then replace it in the definition for treatment with transfer, storage, disposal.
Yes, which is used in the act itself. Okay. I don't see it.
What's
I think they use disposal. No, they do.
disposition is the OCD term. So disposition transfers to, yeah. The final. I support Commissioner Fry's suggestion about eliminating transference and then adjusting, editing treatment to include transferred, storage, disposal. Discharge, transfer, storage, disposal, or reuse.
Yeah. Is that clear? I think we're referring to the proposed language by AB, Amigos Bravos Sierra Club.
Yes.
Everybody comfortable with that? Okay.
I guess has the department's authority been changed when we remove transference? I guess I'm just looking for clarification because their concern was that the department's authority may not be clear to the regulated community if you don't have this in there. So I guess is regulatory clear if we remove transference from this? I'm not totally clear on this issue, so I'm just asking that the department's concern is addressed or in some way.
This is Commissioner Zemlick, I would suggest that transfer, because it's consistent with industry language within oil and gas, is understandable. Transference as a definition for something has another meaning that it's not related to the transport and disposition of produced water.
So transference is used in the definition of wastewater. I don't know if I agree with you that it has any implications, but I just thought I'd bring that to the commission's attention. And then there's a suggestion from Amigos Bravos for wastewater to include further language, but also transference is still within theirs within the current definition.
Transference has a water right notation, doesn't it?
It's an emotional connotation. Transfer is water rights.
Okay, let's go back. Do we want to keep transference in the definitions? And if we want to remove it, then we're going to have to deal with it when we deal with the definition of wastewater. Okay. What's the pleasure of the commission?
I would suggest keeping it in.
Commissioner Harms suggests keeping it in. Commissioner Brancard agrees. Others?
Kind of used definitions and definitions, so I think I'm in agreement with it, since it's used in the definition of wastewater. I'm similar to keeping it. Oh, sorry, I forgot where microphone was.
Okay, so I'm seeing heads nod.
So in treatment, the proposal is to remove it and add transfer, storage, and disposal. Could we not do the same thing in wastewater and have the same meaning? However, I am not an expert in the permitting process, and if they actually use it in permitting on a regular basis, perhaps we should keep it.
Help me out here. Want to keep it or not?
Two sounds strongly to keep it.
Okay.
How strongly does everybody else feel not to?
Edward's got the most experience on the commission. He says keep it. Let's we'll defer to him.
All right.
Treated produced water. I have a suggestion to that. Treated produced water means produced water that's conditioned by mechanical or chemical processes into a reusable form. I'd like to add.
It's in the statute.
I don't care. I'd like to add biological, chemical, physical, or biological processes. And
It's for council.
What's the pleasure?
Well, he said it's in statute, so.
Just to confirm, the current definition
Does not.
is in the statute, and your suggestion is to add biological. But we just had the understanding that statute will supersede rule, so it would be irrelevant to add biological in this case because the statute would supersede.
It's also almost meaningless, but, okay.
To be clear, the statute defines treated water or treated produced water and gives a definition.
Yeah.
But that phrase.
Whoever wrote that statute left something out. Okay, fine. Again, treatment. We talked about this. I think there was some sentiment that we liked the.
Get treated wastewater.
Number 3.
Oh, no, I'm sorry, I did.
That is not in the body of the rule, but it is in the definition for application and reused water, which. But then that's one of those definitions that the words in the definitions, in the definition. I mean, in the phrase.
What do we want to do with this one? You know, we've got, some of these are defined terms that are just so obvious. It's not like we need it, but do we want to keep it? Treated wastewater?
I would suggest keeping it. Sorry, this is Commissioner Harms.
Others?
Keep-
Okay, I'm seeing, looks like I'm seeing agreement to keep treated wastewater wastewater that's undergone treatment. That's circular, but we'll keep it.
I think the point is that it's very broad and it needs to be defined as such.
Okay, and now we've got treatment. And there was an earlier comment that suggested preference for the language suggested by Amigos Bravos Sierra Club, which includes let me just read it. Again, treatment means a process in which wastewater has been reconditioned by biological, chemical, or mechanical or chemical processes to remove or eliminate contaminants, creating an effluent that can be returned to the water cycle either through discharge, transfer, or reuse. And so the suggestion has been to strike transference, and the sentence would then read, return to the water cycle either through discharge, transfer, storage, disposal, or reuse. I think that's a pretty good definition.
This is Commissioner Harms. I think it's missing the temporary storage as well, which was covered under the original definition of transference.
Where did, sorry, this is Commissioner Zemlich, where did that definition originate? Because we're coming, circling back to wastewater, right? Or eventually circling down drain to wastewater?
I don't know.
Since we're talking about the definition of wastewater, it is interesting because Amigos Bravos says here that transfers is only used in other definitions and is confusing because it's defined contrary to its common meaning, yet under the definition for wastewater, Amigos Bravo suggests leaving transference but adding transfer, storage, disposal. So that's a little conflicting in and of itself. I'm not quite sure. So transference obviously has meaning that they recognize because they're including it in that later definition.
No, mine says it should be deleted. It's a little hard. I mean, it's plain the day. I should be zooming in, but I think it suggests the term transference should be deleted and the terms transfer, storage, and disposal used instead.
Yes, but then they include the word still here in wastewater.
Oh, that's what I'm looking at.
Yeah.
I'm looking at the wastewater as proposed by. The confusing part, this is Commissioners, I'm like the term transference is not used in the Clean Water Act. And so I'm trying to find out where it's used. References not in the dairy rule.
Dairy. Help me out.
Well, I've looked it up on the internet, it's Commissioner Brancard. Transference is commonly used in psychology.
That's where I go to when you talk about transference, I have to say. But above that, the first definition is the action of transferring something or the process of being transferred.
It seems if we say transfer, storage, and disposal, and then add transference, we're being redundant.
Yeah.
It's like they forgot to delete it, but then in the next paragraph said it should be deleted.
Yeah.
I think that's just,
I think it's just an error.
Okay. So what's the pleasure? I would like, my preference would be to accept the Amigos Bravos definition of treatment.
So I guess the Commissioner Harms, the lingering question would be the temporary storage. It's not covered in what I see as the proposed change. So the temporary storage is not covered. And that could create a little bit of gray area if something happens, such as a liner failing.
From my perspective, temporary storage, temporary is just redundant. Storage means you're putting it, you're setting it aside for later use. Temporary storage is just
I mean,
repeating.
But it's only temporary because you're in the process of transferring it. So if you include the word temporary before storage right there, you can delete transference without losing anything.
well, but if we're keeping as Commissioner Harms, if we are keeping the definition of transference earlier, then essentially the only reason they're replacing that word is to write it out to be more clear, but they haven't captured the definition that we put above under transference. So you might as well just keep the word transference in there so that it's all encompassing to everything that was originally defined under the definition of transference. You're losing information is what I'm saying by accepting this change.
Even if you add the word temporary before the word storage in Amigos Bravos' proposal?
I suppose if you added temporary, you're missing distribution? You're still missing distribution.
So what if you transferred the words distribution and temporary here and then got rid of the word transference? Then you've captured everything.
Yeah, I think that's the point. You've captured everything, but why do that change when you've already defined transference above?
Okay.
I guess I still lean towards getting rid of transference altogether. Just because scanning the web, transference 9 times out of 10 is psychoanalysis. It's like,
It's not a scientific term. It's not used in the oil and gas industry or in the statute.
But it is used in a regulatory way by the department.
In this,
It might,
it's almost like creating another definition for terms that we're already used to. So if we just include the terms that we already agree upon, then we don't have another definition for the purposes of this rule that's unnecessary.
I mean, I think the department's trying to make the case that it is necessary because it would be consistent with all the other permits that they're writing. But I see your point. I think it would just it's not a barrier we can't overcome. It
Okay.
would just make it easier.
We got to get out of here.
Implementation.
We'll start with this tomorrow.
Okay.
We can think about it.
Can we leave our papers here, Pam?
Yes.
All right.
Take it electronic.
So what time do you want to start tomorrow? Can we start at 8? What time did we start our hearings? Did we start those at 9?
I thought it was 8:30 because we did public comment or something. but-
Yeah. Okay, we'll start at 8:30 tomorrow. Is that okay? I mean, people are already here.
Yeah, I'm not, don't ask me.
8:30. Yeah.
Okay. All right. Thank you. We've come a long ways. And so far, we're all talking to each other on friendly terms. So thank you very much.